mentioned Lordship.
501.
Your Lordship, yesterday your Lordship had passed an order.
You are aware of the procedure here, counsel? We have to teach everything.
The appeal is allowed, rejecting the suit filed before the tribunal, leaving the question of whether the scheduled property is a waqf or not open to be agitated in accordance with law.
With your Lordship's permission, yesterday your Lordship was gracious to allow my anticipatory bail application, and the order has been uploaded on the website, your Lordship. While going through the order, your Lordship, there is a typographical error in para 2 of the order, your Lordship, with regard to the dates mentioned therein and the statement of fact also. Your Lordship may come to page 2.
Page 2.
It is a page 2. It is a matter of record that the appellants Nandika.
Why did correct?
That is not correct. In fact, the Sushila Sharma filed a DB complaint. Thereafter, the complainant responded to file the FIR. And there is dates also, your Lordship.
Which ones?
Your Lordship, it must be, it's a matter of record that the
No,
appellant.
that entire paragraph will remove otherwise.
Your Lordship, but DB complaint and FIR are there. Those
That's
are
not necessary.
Your Lordship, that's your Lordship.
This part of it, actually, I did not dictate it. I thought maybe you picked it up from the earlier order. Protection order.
Yes, Lord.
उसमें से निकाल.
I will check
Dictate
it.
नहीं किया.
मैं check करती हूँ.
Grateful.
In case I will remove it.
Remove.
Item 1.
Item 1.
Wait, please, Your Lordship.
Paper books.
Well, I'm grateful that Your Lordship gave me an opportunity to prepare. Now,
Have you got
on
it?
the face of it, no, paper book is not available.
Then without the
The
paper
High Court judgment and the Trial Court judgment are available on record and placed before Your Lordship. Now,
This is a dismissal of 2018.
no, I'm sure, no,
And then you file a review petition in 2023.
Yes.
Defective, not
Yes.
cured, lodged on February 2nd, 2024.
Yes, Your Lordship is right.
Then you file an appeal.
The only defect in the review petition is that the copy of the SLP paper book is not available. I applied for a certified copy, it is not available with the registry also. Now, Your Lordship had an occasion to look at the judgments. This is a strange case where not even the trial court judgment nor the High Court judgment.
2018.
No, Your Lordship, you kindly
want
bear
us to
with
check
for a
it
minute.
now.
No, Your Lordship, kindly
After
bear.
7 years.
Your Lordship, kindly bear with me. This is may I just place a few facts. The trial court and the High Court both strangely do not record what are the arguments.
Dismissed counsel after
What were you
hearing
doing when the in
This
2018 it come up?
it came through legal aid in 2018 also.
It was heard, was it not in open court?
The review never.
After that, you know
The
about
SLP was it not heard
there
in
was,
open
there
court?
was nothing placed before the Honorable Court along with the SLP. Nothing. It came through legal aid. Now Your Lordship kindly see.
You can't just keep improving the case.
I don't want to improve. I will
And
only.
after 7 years, you want us to now set back.
Your Lordship, on the last date of hearing gave me an opportunity and said that I'll be heard on this date. I prepared the matter and I came. Both judgments of the
Show
trial.
us the judgments.
Yes, Your Lordship, I have the review petition. It's before Your Lordship. Now, the High Court and the Trial Court, there is no independent assessment as to with respect to the evidence that was brought on record. The Trial Court and the High Court nowhere in the entire judgment record that these were the arguments put forth by the counsel for the defense.
Which page is the judgment?
Your Lordship will see the judgment of the High Court is at
Do you want us?
page 19 of the review petition. Page 19.
19.
With all due respect, whatever has been recorded by the trial court, as it is,
Show us
as it
the
is.
relevant paragraphs instead of just seeing
I'm sorry. Your Lordship,
24 witnesses examined.
yes, Lord. Now, nowhere in this judgment, the High Court records the submissions of the counsel for the defense. Nowhere, and so is the case in the trial court's order.
You're
This
just
is a-
repeating the same
Because
thing
it-
again and again without elaborating on why you're saying it.
I'll first place the points,
Not in substantive sentence, 13.
Completed more than 14 years.
Yes, but they've been falsely implicated, that's the whole point. It is a case of circumstantial evidence. May I
Entitled
say,
to be released from
may-
metro release. and
may I just say,
that option open.
the body which was recovered.
There's a complete discussion on the disposition
No,
of all
this is cut copy from the trial court's order, I'll show verbatim, trial court's order has been, cut copy and pasted in the High Court judgment, exactly
Maybe
same
because the
wording.
depositions are taken doesn't mean that there's no application of mine.
There is no independent assessment,
Circumstances are, these circumstances.
These
which are
paragraphs have been picked up from the trial court's order. Exactly the same words have been recorded in the trial court's order and have been placed in the High Court judgment. The body was found after.
The IP was also there.
The body was found after.
No, but leave the style of writing of the judgment.
On the merits.
On merits, there's a PIP, the accused
Just
are
let me
identified.
place 4 facts on merits. Only 4 facts. The first fact is that the body was found from a canal after 14 days. It was not identified by the father of the victim. The father of the victim does not say this is my son, and there was no DNA analysis done by the police or by the hospital to ascertain whether the deceased
Clothes,
is
how is he identified on the basis of?
not identified. PW 23 clearly says not identified, and the body was putrefied to an extent where
According to the IO, how is he identified?
your lordship will have the IO testimony. I am grateful.
The autopsy. Who is the
PW,
IO, PW?
the IO is PW 23. Your lordship will have. I just point the exact page. Page number 12.
He denied the suggestion that the body was not
Yes.
identifiable when it was recovered.
SP page 46. SP petition. Those are the points. Substantial evidence.
And strangely,
The vehicle is also recovered from the possession of the accused.
that's the only circumstance.
So that's a very.
Each circumstance as we.
And
proceed, you
strangely,
say this is the only
the FIR
PIP you are identified, the
the vehicle,
It was
the
hired by the.
your lordship,
all
kindly-
details show
No,
the
there's an-
presence there.
first they found the body, then they fabricated us in this matter. The complaint by the father of the deceased was registered on the 3rd, when he was not even missing. On the 3rd, the DD entry says on the 3rd.
So we'll only say that if you are entitled to be considered under the policy of the state, that will be open to. How we can cancel for the. To interfere with the discharge order dated 2/2/2024. Delay to me. First, you.
The registrar's order is
We find no grounds.
of lodgement of
Comma, having heard the counsel for the petitioner, we find no grounds to interfere with the registrar's order dated 2/2/2024, whereby the defective review petition was lodged owing to the failure of the petitioner to cure the defects therein within time. Even on merits, we find no grounds to interfere with the order dated 5/3/2018 passed by this court, dismissing the special leave petition. Next one, as we are informed that the petitioner has completed 14 years
substantive.
of, over 14 years, over 14 years?
So,
14 years in custody. He would, it is left open to him to seek grant of the metro release of remission if he is eligible for the same under the policy framed by the state.
Great for this.
the miscellaneous application accordingly. Item two,
This matter,
CCTV footage you've not filed.
Not
no, your lordship, actually, we had to place on record the CCTV footage by way of rejoinder. But in all fairness to the accused, the CCTV footage does not implicate.
Show him.
No, it does
So
not.
then why did you,
And
why did you say
TI
that?
also.
No, it was in the investigation stage.
TIP also. No,
Yes.
Then there's nothing.
Yes, sir.
We're informed by the Land Council for the state of Jharkhand that the CCTV footage does not show the respondent. In the view of the matter, we find no grounds to interfere with the impugned judgment and order dated 23/1/2025 passed by the matter, especially petition recording the dismissed.
Item 3.
3,
I am for the petitioner.
Lordship, I'm for the state.
you are not joining the
No, your
investigation.
lordship.
My lord, I'm ready for the joining the investigation, my
You're
lord.
ready for the investigation. They gave you a notice on 29th November, asking you to come on 7th December. You don't turn up. Till date, till 20th January, you have not even turned up. If we give you protection from arrest subject to a condition and you take that condition that lightly, then you're not entitled to this indulgence.
My
Yeah,
lord,
yeah,
and
in discipline,
entire
the police-
prosecution case is rest on the confession of the co-accused, my lord.
Leave all that. We gave you protection subject to the condition. And the counter affidavit
The co-accused-
demonstrates that your father is the co-accused, charge sheet is also filed against him. This kind of attitude we cannot condone. You can't expect indulgence from this court and take what you like and leave the rest of it.
My lord, petitioner is a college clerk, my lord.
Find from the counter affidavit filed by the state of Bihar that despite protection being granted to the petitioner with the order dated 16/10/2025, subject to the condition that he joins and cooperates with the investigation in relation to FIR number 259 of 2025 on the file of so, the petitioner failed to abide by this condition. The counter affidavit reflects that notice dated 29/11/2025 was issued to the petitioner, calling upon him to present himself before the investigating officer on 7/12/2025. But despite such notice, the counter affidavit records that the petitioner has failed to turn up till 20th January 2026. In the light of the aforestated facts, we are of the opinion that the petitioner is not entitled to further indulgence, especially petitions according to dismiss.
Great.
Item 4.
Hey, please.
Here, the counter doesn't say anything about whether
We again served on 22nd/12/25, again served notice personally.
where did you say so in the counter?
It's not there.
When we grant protection subject to a condition and you file a counter after that date, the least that we expect is that you will say whether he is abiding by that condition, as in the earlier case. Here, you don't say anything at all.
In fact, on instruction, I'm saying much. On 22nd, we served
There's no
personally.
instructions. You'll have to put it in writing.
I'll file an.
Ipsit Dixit will not be.
She has been visiting police station whenever she has been called.
Lordship, may fix a date much. Or
Why should we fix a date? You follow the procedure, give it in writing, call upon the petitioner. There's no indication that you even called in your counter at least.
On an earlier date, she was called. She didn't appear much.
That was on 23rd June 25,
Yes.
long before our order dated 17/10/25. And Council for the State of Kerala seeks time to file a better affidavit indicating the developments after the protection order was granted on 17/10/2020. List on 18th March. Earlier order dated 17/10/2025 shall continue to operate to the next hearing.
Obliged.
Like,
Counter. Need time to file a counter.
Taking some time to file counter.
Only served on 15 January. And council appearing for the Narcotics Control Bureau seeks time to file a counter affidavit, usual order after that. List on, how much time would you require?
3 weeks.
Can I pray for interim if possible?
Sorry,
Can I pray for interim?
why would we issue notice if we wanted to grant you interim bail?
No, absolutely, because my only,
If we grant,
I
issue
follow.
notice, it is
I
for
follow,
the
Manoj, I
purpose of
follow.
hearing the other side.
I follow, Manoj, I follow.
16th March.
Grateful.
I did it.
R10 is not served still. Item 6. Oh, 33. Sorry. 30. 33. Is there a scroll or something so that they know that we'll take up the. 33?
Yes,
Yeah.
Lord, in this case,
We'll grant it.
bail has been granted to the accused. Your
7
Lordship.
years he's been in.
Lordship, but kindly see
Both
the
of them
FIR.
have been there.
Kindly see the FIR, Lordship, he is a member of the organized crime.
Whatever it is, we can't hold him guilty before the trial is completed.
Lordship, because they,
27 accused, 122
Your
witnesses.
Lordship, they are filing
completed
one or the
7
other
years.
application, the charges are not been framed. They are deliberately filing this kind of application.
Is he to be kept inside?
Correct.
Just
But Your
because he
Lordship,
has
kindly see the charge
passed.
sheet, FIR.
Whatever be the charge sheet, he still has to be found guilty, is it not? We can't base it on the charge sheet and say, all right, remain in prison for 14 years, even if the trial is not complete. So he'll serve the sentence and then face the trial.
They are the person who are actually,
Whoever it is,
and
the punishment cannot precede the trial, can it?
I
That
understand.
is a simple point. If the system is not working, perhaps we'll need to think about what the state needs to do. Why don't you get the charges framed at least?
Your Lordship,
I'm on advance service in this matter. If my lord's direct, I'll seek.
No, but 7 years the person.
Your Lordship,
I get it.
Charges have not been framed till
Your
now.
Lordship, because every other day they are filing one or the other application for transfer of the petitions. That is the difficulty, Your Lordship. That's why the charges are not even
Stop
framed.
us from doing, taking it.
Accused has come
File
twice to
such
the Supreme Court, Your Lordship.
But at this stage, we can't keep them in prison indefinitely like this without
This
a
is what
trial.
they are deliberately doing it, Your Lordship.
Lords, I appear on caveat. Lords, we had produced the entire Roznama before the Honorable High Court. The Honorable High Court found that there were no adjournments which were sought on our behalf.
Your Lordship, before the trial court, they are
They
doing it,
could
Your
not,
Lordship.
however,
Every
we
other day they
find
are
no good
filing.
ground and reason to interfere with the impugned judgments passed by the High Court. In view of the fact that the accused respondents have been in custody for over 7 years, and there is no possibility of the trial commencing or concluding anytime in the near future.
My lords may permit me to give the.
Especially petitions are according to this
My lords may permit me to give the appearance on it.
appearance.
Obliged, my lords.
Yes, 34. 34. No one? Yes. 34.
Lordship, this is a free fight between two families.
You are the main assailant. You hit him on the head with the axe.
Yes,
He
Lordship,
died of a head injury.
two families, all
Not been inside
accused
for
from
even a
this
year.
side, that side has been granted bail. Lordship,
You are the main assailant though.
Lordship, he was just a 22 years boy. There was a free fight, admittedly.
Well, you killed the father. And you had no respect for his age also. You hit him on the head with an axe. You went inside, got an axe, and then hit him.
From both
It
sides,
wasn't even with you to begin with. You went inside, brought the axe, hit him on the head.
incident happened as spur of moment. From both sides, all family members from both sides are roped in.
If you go inside, think over what should I pick up, an axe or a knife,
That-
and
that
then you
may-
come back outside. With
That
the
may be in a self-defense.
meditated or spur of the moment.
That may be in a self-defense also.
Yes.
But all those things.
What if
will-
there's no mention of the father being armed at all?
When he
Just
came
see,
inside, he could have.
They were aggressors. They came to the house of
Sorry,
the
come.
petitioner lodge.
Delay condoned, however, we find no grounds to interfere with the impugned judgment passed by.
Then lordship may say
At
at
this
present,
stage.
at.
At this stage,
Great,
especially if
great.
petitions accordingly.
Great.
35.
This thing High Court needs a- okay.
My lord, I am for the complainant, my lord.
You're for the complaint.
I'm for the
In 35. There's no 108 VNS, abatement to suicide.
Abatement to suicide.
There's no such charge, is it?
Lord,
The High Court says abatement to suicide. Abatement to
in
suicide.
the
is
FIR it's
108
not,
perhaps.
but during the investigation, my lord,
It's been added.
it's been added, my lord, as my lord,
There's no
state can
mention of
confirm this
108
because the
being
charge
added.
sheet is not yet filed.
No, has it been added in the FIR?
The state has.
We'll seek information.
On what basis does the High Court say abatement to suicide?
Because,
No
my lord,
mention there of the proof.
4 transgenders, my lord, committed suicide.
All 24 of them died.
No, my lord. No.
Then why are you saying
Yes,
committed
absolutely,
suicide?
absolutely.
So for your case, you want to kill off all of them?
Lord, I know, my lord. Not for my case, my lord. State has to confirm that.
And you're the complainant.
I am the complainant, my lord. I am not the one who will be, my lord, put
Now,
in the
are
charge.
there two Sapna? There's a Sapna Haji, Sapna Bai.
No,
Are there two persons?
no, my lord, one only.
This
Elias.
Sapna Bai is also known as Sapna Haji.
Please, my lord. Please, my lord. And, my lord, having 10
He says that I was at home. There's CCTV footage to show that I'm at home.
Yes, my lord.
This lady is somebody else. I'm not Sapna Haji.
No, my lord. There are there is only one person with 2 names. My lord, she was at home, but she instigated these people to
Oh, I see.
consume
She
that.
was at home. And
Even if, my lord,
They ask,
on a dimmer,
Which five is there?
they ask for money.
Months. Can't die at all.
no, my lord.
Then
No. But on a
So
dimmer,
there's no abatement to suicide.
no, my lord.
Only extortion.
I understand, not one extortion. There are 10 cases which are pending against her, and the partner who is Raja Hashmi, my lord.
No, but if it's just a case of extortion, how long do you want her to remain inside?
No, my lord, it's not because of this FIR, my lord.
And according to you, her
And-
extortion also was from long distance. She was on
Lord, it
phone,
was
is it?
continuous harassment. It was continuous harassment to these people, my lord. 24 people, continuous
Well, they
harassment.
go to the hospital and then drink it with the objective of immediately being.
No, my lord.
Is it not?
No, my lord. May I clarify, my lord?
I sit outside the hospital and drink the phenyl.
I have got instructions from the local council also. Why High Court, my lord, Honorable High Court was, my lord, pleased to dismiss it because of one reason. There were n number of videos which wherein she was beating these people, and they were in hospital, and then they drank, my lord. So another FIR is registered for beating them. There's
Anyhow, the
suicide.
petitioner's counsel is not.
Please, my lord.
So,
Item 6.
6.
See,
R10 is not served still, Mr. Gill.
that's only not because the pro forma respondents, we filed an application for
You
deleting
filed an application?
cases.
What is the IA number?
That's not on record.
Yesterday filed, but somehow it is not on.
Lord, it was filed yesterday.
Oh, yesterday.
Can we just hand it to, Lord, we'll hand over a copy to the
Is
others.
it at least
We have a
shown
copy.
in the office report? We need to have some indication of it without, at least the office report not indicating it, we can't take it. The cause list doesn't mention it.
Lord, could your lordships, I'll see that it comes, it's circulated. Could your lordships have it tomorrow? It's only for that. Then if your lordships are pleased to hear it, it'll take only about 10-15 minutes. Challenging an order passed in contempt.
List tomorrow. Sure. List tomorrow. Do you have the IA number?
Sorry,
Ministry is directed to verify and put up IA number.
I'll
Again.
provide
That also you don't have.
E-filing number is there. Give it.
E-filing won't do. At least the diary number, I don't know what they give.
I may not have an objection, may allow his
No, for the IA to come up first, how do we allow something that we don't even know whether it exists or it's been accepted?
I have a-
That one.
Shall I mention you?
Just mention the detail.
Lord, I am compelled to make a request. Mr. Verma has some personal difficulty tomorrow.
Tomorrow. I see. We don't want it tomorrow. Next Wednesday.
Great.
Okay.
Item number 7.
7. R4 is still.
Minutes, I'm seeking-
R6 might be deemed served.
Minutes, I'm
With
seeking permission,
refused, but
I'm seeking permission to file an application for substituted service minutes with respect to the respondent and served minutes.
file an application.
Lordship, I am for
Very well.
respondent 1 and 2.
4 and
in this
6.
case.
6 is deemed served, refused.
Lordship,
According to the office report, R6 refused service. So that's
Minutes.
deemed service. R4 has left
Minutes,
without
I'm
an
seeking-
address.
My lords, allow me to file an application for substitute.
Lordship, this ex parte stay is hurting me, Lordship. It has been more than 2 years. The proceeding before NCRDC has been stayed. Lordship, I seek your leave to file a short synopsis of this case.
No, but we can't.
Lordship, this
Who is
doctrine
R4?
Minutes R4 is one of the respondent minutes, Magic Bricks. They have sought a permission before the NCDRC.
Before the NCDRC,
They have sought the
R4 is,
permission. Yes, minutes.
R4 is the petitioner,
Yes, minutes. Yes.
respondent,
respondent.
Respondent minutes.
is a respondent.
Yes, minutes.
R4 is a respondent.
And they have sought the permission before NCDRC to serve them in NCDRC minutes. In National Consumer Disclosure.
Lordship,
We'll have to.
the service was being completed before NCRDC. Lordship, this order was passed on 23rd of August 2023. They took a ex parte stay on 3rd of November 2023. Since then, the proceedings are being stayed. And Lordship, these facts are not relevant to this order
In 4
because
weeks' time, I'll file an application for substituted service and minutes may have it after 4 weeks.
the plea of
Service
doctrine.
part of it. You may have a point.
Lordship, the plea of doctrine of election was taken.
Rera also says go before the appropriate forum.
Yes,
Obviously, it
Lordship.
is NCDRC. What is the appropriate?
Lordship, RERA doesn't have a jurisdiction in this case
It's
at
not
all.
a registered project. So
It's not a
RERA
registered,
can't,
that is why, Lordship, the trial is being impeded, Lordship, at NCRDC.
On
Let the
minutes,
stay
what
be
what is the
vacated.
point that you have?
Minutes, then minutes may pass it over. Mr. Diwan is appearing in this matter. Minutes.
Lordship, my humble request, let the
Pass it
stay
on.
be. Great, please.
Item 8.
That here.
The Lordship letter has been
Madam,
circulated.
either keep it back or put it here.
There's a letter, is it?
Yes, letter has been circulated.
Government Council for respondent number 1 seeks an adjournment on the ground of ill health. It is accordingly adjourned. List on. March.
Lord, interim order to continue.
Earlier interim order dated 13/9/2024 shall continue to operate.
Oblige.
Item number 9 along with 36.
This also service is incomplete.
Service.
Office report shows
Service is not complete.
service is not complete. And one new item seems to have been tagged on to it. So service would not be complete in that also.
Understand, Manoj, we filed affidavits of service.
Service is complete in all the matters. I see there's
There's
an updated service report which came up.
In 9, it is complete.
9 is. No, but in some of the items, it's not complete, Mr. Ahmed.
I
If
understand.
you see the office report dated 27th
I've
January.
seen that. Manoj. My learned friend
So
instructed. me
because
that
the batch is to be taken up together, we'll have to have the service completed in all the matters.
No, plus I
Then
think
abundant cost-
there's a fresh matter where I'll take instructions to appear for the PS coming first.
Which item? 30?
26, which came in the supplementary
You'll be taking
Filing
notice
my
for all of them,
for the PSC, Kerala process.
only for the PS.
My lords, may the interim order continue that was passed on the last day.
As per the office report, service remains incomplete upon several respondents in this batch of cases. Steps shall be taken to complete service of notice upon them expeditiously, and proof of such service shall be filed. Earlier order of status quo dated 9/12/2024 shall continue to operate in the next hearing. List on, then so many of them are there, so you'll need some time.
4 weeks.
Selection is seldom.
Is held up now because of it.
Lord, there's a status quo order. The order was then to revert back.
Because we were already saying that
Recasting
we are
of
serving.
the degree holders.
We are already
No.
serving.
Appointments were made by the.
No, my lord,
the time? No.
they were under control. There's a
So all
status
those-
quo. order.
In my case, Manoj, they all serve.
Appointed. Total vacancies, how many? Total vacancies, how many?
62 originally, but then most would have come. And the
Most
notice,
of them are appointed.
because of the status quo order, we have kept our hands back.
And Manoj, the
25th.
But we had
PSC
decided once of the office.
the
20
PSC and the
25th
state
February.
supported us.
Grateful, my lords.
Item number 10.
Then also there's a letter.
So there's a letter of interim order.
There is a letter, no doubt, but who is for the, you have to mention what the personal difficulty is.
Yes,
Not just say that due to personal difficulty. We need to examine what that personal difficulty is. What is the personal
The
difficulty?
Lordship, Ms. Rukmini appears in this matter. There is a medical emergency.
Sorry?
Miss Rukmini Bobde appears in the matter. There's a medical emergency in the family. She is out.
Why can't you say that?
Your Lordships, we didn't
Matter
go,
to be kept confidential.
we didn't go in that much details. I apologize.
Then counsel for the respondent seeks adjournment on the ground of personal difficulty. Matter is accordingly adjourned based on March. Earlier interim order dated 23/5/2025 should stand extended till the next hearing.
Motion.
Item
11.
I'm seeking for a pass something led by Mr. Pandey. Sorry, man.
How you placed, Mr. Pandey?
Some difficulty.
Afternoon, you have some difficulty?
Yeah, then let's may have it on, if it's not convenient for me, let's see.
When would you like?
Anytime next week.
Next
week? Yes, sir. Third of course.
We'll take it up on 4th then.
Very great.
Just on 4th.
Good.
Item 12.
12, there's a letter in one of the items, so the batch will have to go.
My lords,
Here again, same issue, personal difficulty without mentioning what the person.
no, my lord, last.
12.2.
Regulated by the.
Please, your lordships.
Babita, 12.2 has a letter. Who is the
12.2 your lordships, I'm appearing online.
For the
Apologies, your lordships.
Oh, it's there in this.
Your lordships, the arguing counsel is severely unwell, because of which
Why
a
don't you
letter
say
has been
that then?
circulated. I bow down, your lordships.
My lords,
There's no need to bow down, but at least be a little more open about whatever reasons you
small request, my lords.
wish to.
One small request, my lords, I'm not objecting for,
Indeed.
but kindly date may be fixed and my lords.
Every matter we
Let's
fix.
fix it, but my lords, in that other way they are circulating a letter and taking adjournment that reasons. Because that my lords 2016 decree I am without any, that's why any date and that may be mentioned as no adjournment will be.
In SLPC number 36211 of 2025 seeks an adjournment on the ground of ill health of the learned arguing counsel.
Yes, indeed, your lordship.
Next date there will be no adjournment like that, my lords, in this case.
What if we want an adjournment?
Well, because my lords, I am suffering for 2016, I haven't decreed no money at all. Then other reason, unnecessary application, my application, and another 2 SLPs are tagged with this matter. That's why, my lord. Any conveyance.
18th February.
My lord, sorry, my
Earlier interim order dated 6/8/2025 should continue.
sorry, my lord, date. My lord,
18th February.
yeah, please, highly appreciate.
Lordships, please, your lordship, we are being led by Mr. Call in this matter and seeking a short pass over here.
Lordships, can this matter be kept on a day, because it will take some substantive time. There's
Today's a day.
Your lordships,
Not a good day today.
no, all I'm urging is, I leave it to your lordship's discretion, but all I'm
If
saying.
you have some difficulty today, you tell us.
I leave it to your lordships.
She wants a Passover. Is it all right with you? Is it not all right?
Lordships, all I was urging was in that particular case, if this matter can be kept after 15 days on a date when it can be heard, because it will take at least 1.
Why can't it be heard today in the afternoon?
Your lordship, Mr. Call is on his way to court only. If the matter can be just passed over for 2 minutes.
Passover will be taken up in the afternoon, not in the morning session. How long will it take? Will it take a whole day?
Your lordships, at least I'll take an hour. That's for sure. I'm for the respondent in this
But
matter.
we-
Substantive
But
issue. which is-
Mr. Call won't take more than 40 minutes.
It'll take some time.
That's 2 hours.
It was fairly.
And how long will you take, Ms. Nirun?
40 minutes.
5 minutes.
That would
So,
But in fact, I was going to make a request. If your lordships were to call it at 2 o'clock, your lordships would find that there is a matter pending before a division bench. Your lordships have made an interim
that
arrangement.
LPA was
That's correct.
14 or something. What happened to that?
So that has to be decided also.
That's still not decided.
That's not decided. So, but if your lordships could call it at 2, the only request I wanted to make, subject to what both my friends would argue. would be,
Or may I suggest, that
further date, your lordships would have the matter directly, High Court to dispose of that LPA.
Yes, because your lordships, the High Court has to only decide.
But
The
if it
issue,
can be- if
the
it can be
question of
called
law
out-
is, your lordships, the question of law which is involved in the matter primarily rests on the fact that when there is a LPA in which there is a stay and there is a binding scheme of arrangement, And when there was no debt and default principally under section 7.
It's a 22 LPA. I don't know whether the.
No, it is
LPAs
pending.
of
It is pending. The
2022 are
matter
being-
is now in April.
Now in Punjab and
The matter is in April.
pendency has gone up hugely
9th
after
March.
I left.
It's on 9th March, your lordships.
The Lordships would call in at 2 o'clock.
It is on 9th March.
At 2 o'clock.
Mr. Call is here now.
Mr. Kaul.
Mr. Call is here. Catch your breath. Have they kept bottles of water here? I've asked for some bottles to be kept. Need some water?
Very kind of you. Thank you.
I may only state one more fact, which I must fairly state, your lordships, if the matter is to proceed, that as far as Mr. Kaul is concerned, he was the counsel for my client, Mr. Amit Chaturvedi.
Oh.
Would not have said, I've got the orders also with me. And because the client wanted to indicate,
You recall that?
yes, these are the orders.
In this matter,
No, for Mr. Amit Chaturvedi, in the entire, yes, in the past. I'm just sharing.
Oh, in
Not
some other matter? In some other matter, it is not very much.
because in the group companies, yes, in
in
the
a
group.
bail application in the High Court is what I'm told.
Your lordships, I'll leave it to his conscience and not saying a word beyond that.
It's 2011,
Very clear conscience.
2011 bail order in the High Court.
I think Mr. Call has a very clear conscience. Why do you bother about it?
Very well, your lordship. That's the case.
No, I'm amazed that you're showing a 2011 bail order to embarrass a counsel. I'm sorry, but these
Your lordships,
practices
I
are.
stated in some other matter, because my client told, I'm leaving it on that. I'm not stating a
But
word
it's
beyond
not as if once you appear for a, especially in the Supreme Court, because they keep changing every appearance,
that. Because your lordship.
depending on who the AOR thinks is our favorite. So depending on that, the seniors also keep changing.
Your
Where
lordship,
is the question of they being tied to the client at the,
your lordships, the client requested me to state, so I'm stating.
Seniors are not expected.
they don't have interaction
Your
with the
lordship,
client, is it not?
Your lordship, it's
They will
only
be
there-
paid by the
I got
AOR.
that.
But I think as counsels also we owed a duty. Just because our client tells us something is not a parrot like we repeated in court. I think it's most
That is
unfair on
not-
your part to have said what you said. Most unfair on your part.
No, it is not unfair. If that's the point, I have stated a fact which my client had
If
instructed to bring to the
counsel had appeared in this matter, you would have a point. Otherwise, they're not tied at, what are they tied at? I forget the expression.
At the hip.
At the hip. They're not joined at the hip.
Your
They're
lordship,
not joined at the hip for him to say that I will never ever appear against Amit, whatever his name is.
15 years later, some order after
So your lordship.
4 orders in this matter.
All I'm urging is,
is a-
it'll take some time. If they want to proceed, then it's okay. And otherwise, if he was suggesting, as Mr. Niranjan Reddy was suggesting, on that point.
No, but if there's no possibility of that 2022 LPA being heard by the.
It's a 9th March.
Why?
It's a 9th March.
Yes, yes.
It's a 9th of
Why
March.
should we keep it pending?
I'll show. It's a 9th of March, your lordships.
9th of March for what though?
For the purpose
Under
of.
which heading is it coming up?
Lords, may I with respect say, subject to whenever your lordship wants to hear it.
We are
Ultimately,
open to hearing it today.
no, I'm here to assist your lordships. All that I'm saying is one thing, and then I leave it to your lordships. That
Yes.
LPA will have no bearing. Because all that they are talking about is that a stay of that LPA revives the so-called order sanctioning a scheme 11 years after its initial movement. Even that order directed that within 30 days, you will file it with the ROC. You did not file it for 4 years after that. So there is no sanction scheme, and after 10 years, your debt, which was 6.5 or 10 crores at one time, has become 150 crores. The creditors have withdrawn consent. And you're talking about a valid scheme under section 391 of the Companies Act.
Your lordships, it's indicated on the top, 9th March. Your lordships, right-hand side top, next date.
And it's still showing under interim relief. It's not for hearing.
But your lordships.
What does that mean? And from my own experience, I can tell you in Punjab and Haryana, you'll be lucky if your matter comes up more than once a year. So then we'll hear the matter. Yes.
Yes. Well, let me give your lordships a brief overview of the matter before I come to the specific details, which I'll come to in a while.
Success.
I think I should also do this.
Just to give a brief overview before I come to the specifics.
Yes.
Around 1999, 2000, my lord, about a loan of 10.60 crores is given to the corporate debtor. Various.
When was it? 10.6 crores?
In between 5/4/99 and 12/12/90 and 2000, the loan was disbursed.
When? 12/12/2000.
12/12/2000.
12/12. Yes.
Now, various SICA, SSC proceedings started. And then ultimately in 2008, my lords, a scheme of arrangement was formulated. And the High Court directed.
Yes.
Because I'll give the specific dates when I come to, and then I'll give the specific dates. So just an overview. So the High Court directed, as your lordships are well aware under section 391, that please go to the creditors and get the consent of 3/4 of the creditors. And if that is done, then as your lordships note, the chairperson gives the report and it's presented to the company court for a second motion.
Yes.
Now, the statute is very clear on it, how it ought to be done. They did nothing after the creditors gave their consent for a settlement around 2008. Now, after that, my lords, the creditors, since they were not moving the second motion, because ultimately they would have had to pay the money, ultimately the creditors wrote to them to say that, look, if you do not move the High Court for the scheme, we will withdraw our consent. Now, after they are told to do so, they still don't do it. And the creditors write to them to say, we have withdrawn consent to any scheme. After that is done, the respondent application for sanction of the scheme. After the creditors have all withdrawn their consent. And this keeps lying and is not prosecuted by them for 10 years. Nothing happens in this. Now, in the meantime, my lords, the creditors file a section 7 in 2018, and the section 7, the amount by them has ballooned to 154.33 crores in 2018.
Yes.
Now, after this section 7 is filed, suddenly on 23rd/7/2019, the High Court sanctions the scheme of arrangement, which was initially approved and consent withdrawn in 2008-2009, which was meant to be filed back with the...
Were you not a party to that?
Please, my lords. Yes, our predecessors.
July 2019.
Yes.
You were heard.
No, my lords, we were not. The predecessor in interest, but the best of our instructions are that it was sanctioned on that date. But I'll get better instructions on that. Let me get better
Who appeared on that?
Who appeared? I'll just get this to know who appeared on that day in that matter and what happened. Just check that. Now, in any case, my lords, what happens is that we file an application for recalling of this order, sanctioning the scheme, because it is pointed out in therein that that initial application, which was to come in within 15 or 20 days when I show the statutory scheme, was brought in 1 year after the statutory period, after the creditors has withdrawn consent. And after that application or second motion is made, 10 years later, it is sanctioned. And this fact was not brought to the court's notice. And secondly, that the creditors had withdrawn consent was not brought to the court's notice. So these facts are pointed out in a recall application. The High Court passes an order recalling the order, and rightly does so, because once the consent has been withdrawn by the creditors under 391, which requires 3/4, where is the question of sanctioning a scheme, which had to be done within a statutory period? It is that order recalling the scheme, which is stayed in the LPA and is pending. And their contention is because of that, the order sanctioning the scheme has been made alive again. Now, that ignores 2 or 3 fundamental issues, my lords. One is that order, which could not have been passed sanctioning the scheme, itself said that you had to file with the ROC or the registrar within 30 days. And that's a statutory requirement, 15 days or whatever the court provides for. And the sanctioning is not valid till that filing takes place. So, you do not file within the time provided. You actually file 4 years later in 2023 with the ROC.
After the 23rd July 2000.
Yes. 4 years later with the ROC. Now, in the meantime, the section 7 comes up. The NCLT deals with it. And the NCLT rightly passes the order admitting the section 7 petition, saying that, my lord, there are now series of judgments of your lordship of the NCLAT and NCLT where appeals have been dismissed by this court, saying that 238 of the IBC has an overriding impact. It has a non-obstante clause. B, IBC is a completely separate proceeding. Even you have some other proceeding going on that will in no way affect the IBC, where time value for money and expeditious disposal have been held to be the heart and soul of IBC. And in such matters, merely because there is a pendency of any other proceeding makes no difference. Then the court goes on and says that, look, all that we are required to see under IBC and section 7 is, in terms of innovative and other judgments, is there a debt and default or not? If there is a debt and default, that is the end of the matter as far as the IBC is concerned. And secondly, in the light of the Tulip judgment and other judgments of the Supreme Court, even a dispute as to the quantum of the amount involved is of no consequence at all, as long as there's a debt above the threshold limit. Now, admittedly here, from 2000, you have not made any payment at all that you are required to pay. Even earlier you delayed because, as we presume now, that even under that scheme of arrangement, which you arrived at that stage, you didn't have that money to pay, so you kept delaying. Till the creditors started moving, withdrew consent, then you suddenly filed it after a year. And then for 10 years you did nothing with it, and suddenly then the scheme gets sanctioned. Now, if in this time frame, IBC proceedings are permitted to be delayed, to say that, look, my scheme stands sanctioned, the LPA has stayed the order recalling it, so it's been revived, and thus no section 7 should go on in the matter. Now, since then, my lords, plans have been invited and are now under consideration before the COC. Now, in this kind of a situation, my lord, your lordships were kind enough on the first day, because RP had been in control since 2024, my lords, and then briefly because of the order of the NCLAT was divested of the control which your lordships restored with the order that your lordships passed, issuing notice in the matter. Now, my lords, this order of NCLT was this order of NCLT was set aside by NCLAT, and it said that the section 7 petition will be kept in abeyance until the LPA is decided, and in the meantime the NCLT order, the 27/2024 order, is set aside. Now, my lords, that is the order that we came before your lordships against by way of an appeal, because A, that proceeding cannot in any way stop the IBC from proceeding with the matter, one. Secondly, my lords, the facts of the case are telling and important. in this matter that can a party which is meant to pay amounts in 2000 takes a loan, in 2008 has a scheme of arrangement, doesn't pay, then suddenly in 2019 after the creditors have withdrawn consent, gets a scheme sanction which is recalled and stayed in an LPA, come forward and say that the IBC will not go on, which in any case has a non-obstante clause, and your Lordship's judgments have said is a completely independent proceedings. My lords, that is the conspectus of the matter. And even as per that belated sanctioning order, the ROC filing did not take place. So there was no valid scheme as required, even if that order is taken to be a correct order, was not done. And your belated filing in 2023 will not make a difference at all that you did with the ROC. In any case, my lords, what they now come and say is, subject to verification, that apparently 37 or 38% of the creditors come and say that apparently 37-38% creditors have again given their consent. I mean, that still doesn't meet the threshold of 3/4 under 391, which is not there. Secondly, the NCLT even at that stage said, when it passed the order in 2024, where is the approval of the ROC? There was no approval. What they now produce here in the proceedings before your lordships is a 2023 filing. That is the broad conspectus in which I will give your lordships the relevant dates and the law on the point.
Let us just look at the stay order in the LPA ones.
Yes, sir.
Page 150.
Yes. Learned senior counsel for the appellant inter alia contends that while passing the order dated 23/7/19, a specified finding has been given in para 5 at page 445 of the paper book that during the pendency of the appeal, respondent number 7 took over the debt of respondent number 1, 3 and 6. Vede order dated so-and-so, respondent 1, 3 and 6 were discharged. Thereafter, respondent number 7 was treated as a party and debt of respondent was liquidated. Thus, there was no procedural lapse in recording the fact that respondent 7 has taken over the debt of respondent 1, 3 and 6. It has further been submitted the debt of 1, 3 and 6 comes to more than 70% of the debt of respondent number 5 is added. It would come to more than 75%. Hence, there is no procedural lapse in recording the above finding.
You are respondent number 7.
We are respondent number no.
Who is respondent number 7 there?
Someone who's taken over the debt of some of the other creditors.
And that person consented to this.
Yeah.
There's no mention as to. There's only an appearance for the counsel for the appellant. There's no one appearing for the respondents at all.
Yes, madam. This
was an ex parte.
This is the one. This was an ex parte order.
It's 2822 order. Which is that?
Order 2822 is recalling. No, we need to understand this array of parties in the LPA. Do we have the cause title of the LPA?
What? No.
Who took over the debt?
One of the creditors.
Which one was it and what was the percentage?
IDBI, I think, my lords, transferred the loan to what is called the Stressed Asset Stabilization Fund. And from the Stressed Asset Stabilization Fund, then it comes to us. I don't know whether
IDBI must be a party in the LPA also.
I have to confess, I don't think the LPA with the memo of parties
it's not there.
I have to
need to at least understand who is.
I can do one thing. I can, whatever your lordship says, I can either.
for the order.
Yes.
For the
Well, I
completeness
can
of the
do-
order, at least we need to know. who's-
I can do one thing subject to what your lordship says. Either I can continue or I can come back a week later with at least this order that your lordships have pointed out on who took how much of the debt and what.
This seems to indicate that the counsel for the appellant projected it as if.
Yes,
the
yes.
75%
I have to confess that I overlooked it. I had not seen it till your lordships pointed it out. I need to also, I'll have a look at this also. And I can get the array of parties and the LPA also fine. Whatever your lordship says, otherwise I could continue with the.
No, because it's better that.
No, so your lordship would want me to get the LPA file, why not? Should I file the LA?
File a copy of the
LPA with the array of.
The LPA as well as the earlier order, that 2822 order, that is already on record, I think. This 2822 is already there, 140 to 140.
Yes, yes.
And the 23719 is also there,
Yes,
but we don't have
yes.
a copy of the LPA there.
We'll have that file, my lord.
You are appearing for
Yes.
R1,
Yes.
Dwarakadish.
Yes, for Amit Chaturvedi.
Who is the director of this company?
Yes.
Madam.
And who had filed the appeal before the NCLAT.
And you did it in your individual capacity
He did it in his individual capacity.
against an order of admission of the CIR.
Yes. Yes, your lordships.
How are you entitled to do
Your
that?
lordships also as a shareholder and the
No,
guarantor.
you filed it not as Amit Chaturvedi. You filed it in the name of Dwarakadish.
No, I filed it as Amit Chaturvedi.
Amit Chaturvedi.
Yes, your lordships. In the very first instance.
Next.
Next one.
Show us the
5A.
Your lordships, I'll just show you the appeal.
Very well. You showed yourself as.
In fact, my lord, this is happening in a lot of matters. The ex-promoters, whom your repeated judgments of your lordships have said that as far as possible, keep them away, because they are the ones who grounded the company to dust, are the ones who most passionately pursue the case of the corporate debtor, and in most of them, ultimately, the court holds what is your locus and what are you doing in these matters.
Your lordships, we'll prove it.
And you're appearing for whom?
For R2, who is the RP?
RPs. So now you are at least back in the saddle.
Yes.
But you have to keep the board of directors informed about
No
what.
further steps should be taken in terms of progress.
Your lordships, page number 1206 shows the appeal title. If your lordships, page number 1206.
So.
Wednesday then.
Very well.
Next
Much
Wednesday.
right, your lord.
Next Wednesday.
And page 1206 is the cost title. Of the.
Manoj, let me check up about the 70% also. Let me come back with both the issues, because this statement is made, which frankly, as I said, I had not had a look at. I'll just check this up. And what is the current status of the so-called consent of how many creditors is there? Let me just check that out. Very grateful.
Item 14.
Lordship, no counter.
Item 14, we have filed a counter last night.
Last night.
The same may be come on the record, seeking a short accommodation.
Who appears for the petition?
Lordship, I appear for the petitioner.
You need to file a rejoinder.
Please, Lordship, I'll need.
We are informed that a counter affidavit was filed yesterday. Registry is directed to verify and adopt the same. Full stop. Then counsel for the petitioner seeks time to file a rejoinder to the aforestated counter. Equal in that regard shall be done within
2 weeks, Your Lordship.
2 weeks, based on 26th February.
Lordship, interim order to continue.
Earlier interim order dated 18/9/2025. Continue to operate in the next hearing.
Item
We are
15.
ready for the Lordship.
15. We received a copy of the affidavit filed.
Your Lordship, the other side, the municipal council has filed the affidavit.
Affidavit showing that all the debris, everything is lying there, you've not removed.
Your Lordship, only
How much is the amount lying in deposit here?
Yes, please, Your Lordship.
Well, it's annual for respondent number 6, the councils for respondent number 2 and 3 per year.
5,36,000.
thinking that the matter would go on.
That item 13 would go
So
on.
how much was the amount which was lying with deposit? I couldn't get the details.
5,36,450.
Well, they are saying that it cost them 16 lakhs to remove this.
Your Lordship, just one note.
No, but you gave us an undertaking that you would do
Yes,
that.
Your Lordship.
And then you don't go abide by the undertaking.
Your Lordship, I am just telling you one fact. The 72 shops has been demolished by me. Your Lordship,
Demolished doesn't mean that you leave everything there.
Your Lordship, just see the affidavit and photograph date
Look
of the
at the photographs.
Your Lordship, see the date of the photograph is of the 15th December 2025. The last order was passed on 16 December
Where did you
2025.
find the date on this?
At the bottom of the photographs, Your Lordship, the clicking date, the Monday is the last on the at the bottom.
Which page are you looking?
Page 4 at bottom, Your Lordship.
At the bottom?
Bottom yellow. Where the description is given. January 2026.
Oh, this one. This one is.
Description is there, the date is there, Your Lordship, Monday 15.
So according to you, you've cleared everything, is it?
Your Lordship, the 16 was the last date. After the last date, the broken pillar was also removed. But the municipal, we have given the letter to the council also.
Why haven't you filed a copy of whatever?
Your Lordship, they have filed this affidavit just on Saturday, 24th January 2026. The 25th, 26th, the vacation.
How long does it take for you to take pictures and file them?
Your Lordship, I will file the affidavit, the better affidavit, Your Lordship, reply affidavit to this.
Are removed. It's not merely demolished.
Removed.
Admittedly, we are in the possession of the property. It's not the case where we have to hand over the possession to the other side.
File photograph then. Let us see what, according to you, is the present position.
And the debris is in my property, Your Lordship. So,
affidavit filed by respondent number 2, along with the photographs, is taken on record. Learned counsel for the petitioners seeks time to file his response thereto, along with supporting photographs, as it is his claim that the petitioners have not only demolished the construction but also removed the debris.
no, Lordship, debris is, I'm not just saying that the broken pillar was removed as per the picture.
So you've left everything there.
Your Lordship, debris, I have no instruction from the client. I will
We
file
said
the affidavit.
remove the construction, which means that the land should be clear.
Your Lordship, just.
So you do that now and then file a photograph. Then we'll see whether you're abiding by the undertaking.
So, Your Lordship, just don't record. Please don't record in the submission. I will file the affidavit.
Along with supporting photographs.
Photographs.
If we find that any debris is there, then obviously you're not.
But Your Lordship, as per the High Court order, I am in the possession of the
Consequences will
property.
follow.
Okay.
Advise your clients that they just can't take undertakings this lightly.
Plus, I'm permitted to give my physical appeal.
Yes.
Like,
Date, how much time do you require?
2 weeks, 4 weeks.
26 February. Questions not filed.
May I please your lordship, sir.
Mr. Attorney General.
No,
on
I've taken
November-
stock of the matter now. I've taken stock of the matter now. In fact, I sent a message to my learned friend, and we are preparing the process of preparing a status report. On many aspects, I think there have been some good work has been taken place. So let me give a status report in about 2 weeks' time. Then lordships can thereafter hear this matter.
Matter is just getting adjourned from time to time. There's
No, I have now taken stock.
Now
of the
we
matter.
have someone who wants to intervene and give some more suggestions.
Yeah.
Who's for the- Yeah? Have you received a copy of it, Mr. Mike? Someone filed an intervention petition.
No, I have not received.
We haven't received it.
There is max.
There's an intervention yesterday, I saw it.
Speaking also.
No? It's 16 only.
This is of course
Some
happens
intervention.
frequently. A Vicus doesn't get it.
No,
They
I
don't
saw
serve. They just
it.
file. I don't know how it works.
Okay. They stay in the circulation, it had come late at night. Or maybe it's in 16.1. 16.1 it was.
The whole of this party and nuisance. Identical.
Yeah.
Separate application.
And 26. That 25th and 26th we have GM. That will be difficult. That's my
This report seems to mention it. 16.1 it was filed and Mr. Ashwini's marks.
Second week.
Have you received a copy of the?
Yes or no? 2020, my learned friends all confirmed they have not received.
Circulated. I saw an international application. Anyhow, the council is also not here.
Now, can I just take 2 minutes? Sanjay Michael, your lordship will put it sometime in March. It's there.
Very
I mean, two things. One, there is a written submission, the older one, filed in August of 25. Now, I have now changed the provisions to the BNS, which is subsequent. So, the same thing will be read, only the provisions will change. So, I made a 2-pager on the prayer, the recommendations which I am suggesting respectfully to the court.
Yeah.
That part only I will hand over and it can be circulated or given. It's the same thing.
Furnished it to the attorney also?
Attorney, I will just give it down because it's the sections basically change. I'll make sure he gets it. It's broad, it's almost identical, but for the sections. Number one. Number two, I hope these inputs come in advance so we can make a chart. In the light of my written submissions, whatever inputs my learned friend Mr. Attorney gives.
I propose to do that myself. We'll try to do that.
Take in advance.
Yes.
My suggestions where the guidelines is also before your lordships.
That's also communicated to the attorney?
Yes, that's all with it.
Please take note of all that has come.
I will collect all of them and see that. Yes.
Whatever it is.
My only respectful submission is, the lordships know, it's a matter of highest priority. Lordships are hearing it in March. Any dates suitable to your lordships, may be kept, because this will require some time, because the matter is so critically important. It has been pending since 2020. And I think now it will see the light of the day with the learned attorney now itself.
Attorney General, to file a status report, ensuring that advance copies are circulated to all the joint council appearing in the March, including the one from SSC.
4th of March.
Holidays.
4th March.
Holy break. Holy break.
Oh, holy.
18th March.
18th March.
18th March. Very well. Grateful to Lord.
Hope is not served.
Some notice, sorry. In item 15, your lordship, the maybe date 25th February, if your lordship is.
Sorry?
Convenient. Date maybe 25th, 26th February, your lordship is.
In which item?
15.
15.
25th February, it may be.
What have we given?
26th February.
26th.
25th is the working day.
25th is
Wednesday.
Or 24th.
Wednesday.
Obliged.
I believe the service is pending.
Service is pending is what I'm.
I appear for respondent number 90. We have received service.
No, but according to the office report, the service is not complete in all the matters.
It's on the post.
Now, there seems to be some issue about whether these 25 or 29. 29 mining lessees whom you said were free of any wrongdoing.
I've filed that report.
According to the other side, there seems to be some issue about it.
Not according to other side. There's an intervener who has filed without even coming before the High Court. Intervener comes here.
But we also have your own officer backing out before the High
No,
Court.
that was only one. That was on the questions of the learned Chief Justice then, that the officer said
No,
something.
but did she do it voluntarily? Is she saying something that is contrary to the
No, but
record?
it is contrary to the record. Contrary to the record.
She's a signatory to
She's
that
a signatory to the report.
And then she says something contrary to
Correct.
what is stated in
Correct.
the report. So
Correct.
what do we do with that then?
That can't be once you have signed a report and 5 other officers have
We
signed
don't
the
know. The High Court in fact wanted to initiate contempt against you because you initiated disciplinary proceedings against
No,
you.
not disciplinary. We gave a show cause notice that having signed the report, how do you give contrary submissions before the High Court? So of course,
And
then of
what
course,
happened then?
no, then your
Maybe
lordship.
it's better that you ask that lady to come here and tell us whether what the real.
I have no issues, Lord.
Because it's better then, because we don't know whether she's being pressurized to give a false report.
Why other 5 officers, Lord, would have signed that?
We don't know. We don't know what is happening there. But we would like to have the truth.
Correct.
Because we were led to believe that these mining lessees are doing everything according to the norms.
Only 29 out of all those, Lord.
But according to this intervener, according to that lady also, those 29 are also not doing everything.
No, according to the intervener, the statement made is that that report is false. That is one.
That's
casual.
What about that lady? She also goes before the High Court and says, yes, they
No, she says not. She doesn't say that the report is false. She says that the report was prepared for administrative purposes.
They are doing everything as per the rule book, something like that.
Yes.
The High Court
Now
record.
please have a look at the report, Lord, which we have filed.
Better you call that lady and ask her.
Call
to
that.
present.
Something.
What is her name?
What is it?
The order. One of the
I'll
orders.
just tell your lordship, Lord. No, order only record.
Orders perhaps.
Order is Lakshman Singh, Additional Secretary, to whom the notice was issued.
There was one of the
DMO.
orders.
Lord, it refers to her as DMO.
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 Without mentioning the name.
Without mentioning
But
the
her name came somewhere, Mr. Admara.
District Mining Officer. Para 2 onwards, Lord, District Mining Officer is present.
On an earlier hearing, during an earlier hearing, you showed us the report.
Her name is Nazia Hassan.
Nazia Hassan. Miss Nazia Hassan, DMO, District Mining Officer.
Lord, in fact, your
Who
lordship,
appeared before the High Court.
summon all these people who have summoned the reports.
Be
They shall explain to your lordship.
We don't want to free for all here now. She's the one who said something contrary to that report. Let her explain why she said it. Whether she's being pressurized one way or the other. Shall be present before this court. The state shall bear the expenses for her to and fro travel and her boarding and lodging.
So that is, she's a government servant, Lord.
Whatever.
Because
We are asking her to come, don't make her pay for.
Not at all. How can that once it's a court order?
So,
under the rules, she's Lord, the interim relief stipend.
earlier interim order shall continue till next hearing. This one, when shall we take it?
Somewhere in February, but except 11 to 13. After that or before?
18.
18. Lordship, grateful.
Item 18.
One moment.
I
One moment.
want to make a small.
One moment.
Lordship, I was in item 16, respondent number 2.
Yeah.
I just seek permission to file physical appearance.
Please, my lords, I appear for the petitioner in item 18, my lords. The
Yes.
issue involved in this matter is, my lords, the entire criminal proceedings has been quashed by the High Court, my lords. My lords, may kindly have the impugned order at page 2,
Was here
last
second.
paragraph.
You're here?
Please, my lords.
Right. Yes.
My lords, may
Impugned order.
kindly have the impugned order, the last paragraph, my lords. My lords, have page 2.
Yes.
After aforementioned first information report was lodged, investigating
One
officer.
moment. Which order are you reading?
My lords, I'm reading the impugned order, page 2, my lords.
Page 2. Very well.
Please, my lords.
After
The last paragraph, my lords.
Yes.
After
Yes.
aforementioned first information report was lodged, investigating officer proceeded with the statutory investigation of concerned case crime number in terms of chapter so and so. He examined the first informant and other witnesses under section 161 of CRPC. The witness so examined have substantially supported the FIR. On the basis of the above, the other material collected by the investigating officer during the course of investigation, he came to the conclusion that the complexity of the all name accused established in the crime in question. He accordingly submitted the police report under section 173(2) of the CRPC dated 30th September 2022, whereby the aforementioned name accused have been charge sheeted under section 419 and 420 of the IPC. After submissions of the aforesaid police report, the concerned magistrate in exercise of jurisdiction under section 191B of CRPC took cognizance upon the same and registered a case. Consequently, the charge sheet accused applicants were summoned by the court below in crime number so and so arising out of crime number so and so under section 419 and 420 of IPC. White summoning order dated 14/11/22 passed by the Chief Judicial Magistrate Jaunpur. My lords, thereafter, the court on two grounds have quashed the proceeding. One is on the ground of delay and other relying on a judgment which was in pertaining to bank officials under the SURFACE Act, my lords. My lords, may kindly have the next para, just leave one para. Learned counsel for applicant has first invited attention of the court to the first information report giving rise to the present criminal proceeding. With reference to above, he submits that as per the prosecution story as unfolded in the first information report, the occurrence gave rise to the present criminal proceeding is alleged to have occurred on 10/10/2019. Well, that was the date when the checks were handed over to the accused person. Whereas the first information report was lodged on 17/6/22 after an expiry of more than 2 years and 8 months. He therefore submits that there is a delay in lodging the first information report. He neither in the first FIR nor in the statement the first informant recorded under section 161 of there is any explanation with regard to the delay in lodging the FIR. It is thus urged that since the delay in lodging the first information report has not been sufficiently explained, therefore the consequent criminal proceeding pending against the applicant arising out of the FIR cannot be sustained. Now, my lords, the judgment that they are relying upon is a judgment which was under 302 of the IPC, my lords, and it was after the trial when the parties were permitted to lead evidence. Whereas, my lords, here without any trial, without an opportunity of leading any evidence, this judgment has been applied in this case and it has been held to be beyond the limitation, my lords. Now, the relevant portion has been quoted, my lords. If my lords will see, it is the part of the judgment. Normally, the court may reject the case of the prosecution in case of an inordinate delay in lodging the first information report because of the possibility of the by the prosecution. However, if the delay is satisfactory, explained, the court will decide the matter on merits.
Then there is two.
Yes.
Now, my lords, this is the part that they have quoted. My lords, now I'll take my lords. My lords may have page 5 and
No,
the
next
third paragraph.
paragraph after the extraction also.
Please, my lords.
It is then contended that
Then contended that proceedings under section 131 of were initiated by Vinod Kumar against the first informant Chandrasekhar Bharti by way of a complaint number so and so. Malas, it's an admitted fact that they have initiated two proceedings against my client under 138, my lords, for these very checks, my lords, and I am participating in those proceedings, my lords. But my case is, my lords, for those.
Why didn't they file it within 2 years?
Malas, it was when I received bailable warrants in those cases, then I realized that they have misused the checks and then I filed a criminal complaint, my lords. And my lords, after investigation, the investigating officer has found material. In fact, my lords, they say I have given them 10 lakhs and some amount for purchase of land. but they have not shown even a single document along with their 138 proceedings or before this honorable court establishing whether there was a transaction or not. It's an admitted fact that the petitioner and the
But
respondent were.
if you were summoned in 2020 itself.
No, my lords. He
and
was
sent out
summoned
this
only
so-called check.
in 2022, my lords. He received the non-bailable warrants on my lords in 2022, and thereafter he filed.
Non-bailable warrant would be later. When was the summons issued?
My lords, he did not receive the summons. In fact, he did not even get the legal. My lords may kindly consider that the period of the when the checks were presented.
Must have been served.
It must have been served.
Why would a NBW be issued unless
My
summons
lords,
was served on the page
my
of
lords
the-
may kindly consider, my lords, what had happened was this was the COVID period, my lords. The checks were presented on 16 January 2020 and 24th February 2020, my lords. Therefore, my lords, March onwards, there was a COVID situation, my lords.
16 January and
My lords, first check was presented on 16 January 2020 for 10 lakhs by Lakshmi Narayan. The check number is 21005820.
The
And
second one?
second was on 24th February 2020. The check amount was 3,50,000 and it was by Vinod Kumar. The check number is 21005810, my lords.
And when was the case filed? Complaint
My
case?
lords, that they will have to explain. Those dates are not coming in their reply, my lords. But I got to know only on 11/4/2022, my lords, when bailable warrants were served upon me, my lords. My lords may kindly consider during that period
Is
the
that
COVID
order
was going
there?
on.
Is the order issuing the NBW against you available?
No, my lords, it is not on record. My lords, if my lords
Then
want, I
how
can
do we
file
know
it.
whether the service of summons took place or not?
Says that finance of a vehicle to be.
My lords, my complaint is there, which is at page 37, after which I have filed, my lords.
To you, you gave the money to them for purchase of a vehicle.
Yes, no, my lords. I gave them those checks to arrange a vehicle for me, my lords. That they were my friends, my lords. They were known to each other, my lords. They said
You're an aggregate, they are teachers.
no, well, they are teachers, but they were known to each other. In fact, their case is also that we were known to each other's, my lords. In fact, their stand why the money was given is
The
contradictory,
transaction
my
is
lords.
entirely different as projected by them.
My lords,
You're not even on the same page there.
2019, she admits that she wanted to purchase a he wanted to purchase.
Vehicle then.
There's no vehicle purchased.
No, my lords. Subsequently, a vehicle was purchased, my lords, by himself. They did not arrange for any loan or any vehicle, my lords. My
No,
lords,
you
may
did not-
kindly
you
look
did-
at this stand
Madam, wait a minute. You did not get a vehicle.
from them. Yes, my lords. They did not arrange the vehicle. I, on my own, arranged it subsequently.
Okay. So in 2019, you gave them 5 checks for arranging a vehicle on finance. So then if it was not arranged within 6 months, you should have filed an FIR then and why did you wait till 130 and all
My
that?
lords, may kindly consider that was a COVID period. My lords, March 2020, COVID started and everybody was.
10/10/2019, March 2020, that is almost 6 months thereafter.
My lords, that's
10/10
what I'm saying. The checks were only presented on 16th January 2020.
Madam, we are asking you something else. You say that you handed over the checks on 10/10/2019 for the purpose of purchasing a vehicle.
Please, my lords.
Admittedly, no vehicle was purchased. Why did you not initiate proceedings then and there?
My lords may kindly, that's what I'm saying, my lords, the checks, in fact, these questions are matter of trial, my lords. He's going to lead evidence. If there is no evidence, his complaint will be dismissed in any case, my
Your
lords.
story also sounds a little difficult
My lords
to.
may kindly see their story, my lords, for
Being
one.
an advocate, expect these teachers to arrange a vehicle for you.
My lords, they were known to us, my lord, that is why. My lords may kindly look at page 75 of my SLB,
According
my
to
lords.
them, you said that you would provide money, provide land to them, you took their money.
My lords,
and
that's
because
what I'm
you didn't
saying.
do that, you gave them checks.
My lords may kindly look at their stand
That
at page.
sounds more plausible there.
My lords may kindly have their stand before the High Court at page 75, my lords. The stand was entirely different before High Court is what has been stated before this court, my lords. My lords may kindly have page 75, my
Your
lords. It is.
story though, and there's delay, on the face of it, there's clear delay.
My
Leave
lords,
the application of a judgment.
my lords, whether
On the
there is
face
a
of it,
delay
there's
or
no
not
delay on
delay,
your
my lords,
part.
it's a matter of trial as on date, my lords. I can explain that delay. My lords may kindly have page 75.
Nothing,
My lords may
nothing. in this.
kindly, my lords may just one point I'll show, my lords, and then I will not approach, my lords. My lords may have page 75, my lords.
75,
Para 7, my lords.
yes.
My lords, it is their petition before the High Court where they were seeking quashing that initially the opposite party number 2, my lords, that is my client, taken the money as a borrow for the purpose of initiation of the business. And when the petitioner demanded given check mentioned in the first information report, the same has been presented before the bank, the faucet was dishonored. So, my lords, the stand before the High Court is completely different from what has been stated before this honorable court, my lords. It is a relevant factor, my lords, that they have not been explained.
They are entitled to take divergent stance in the proceeding.
My lords, their stand, my lords, they have not
Counsel for the
even,
parties.
my lords, they have not even shown any document showing that I have given them 10 lakhs of rupees. And
We find no good ground and reason to interfere with the interim judgment passed by
my lords,
the.
I'm covered by a judgment of this honorable
Please
court
according-
only on this, my lords.
These matters, precedents don't apply. The criminal cases and all will have to turn on the individual facts.
My lords, we have the
I'm so
instructions
grateful, my lords.
for the present specially
Which
petition.
one?
Item 19.
19. And Council, what is your name, Council?
My lords, Bharat Sood, on behalf of Mr. P.S. Sudhir.
Mr. Bharat Singh.
Bharat Sood.
Bharat Sood. Mr. Bharat Sood, Learned Council. Give it in writing, please.
Yes.
Learned Council representing Mr. P.S. Sudhir, Learned advocate on record for the petitioner, states on instructions that the petitioner wishes to withdraw the specially petition. According to the said statement, the specially petition is dismissed as
Right.
Grateful.
20.
No, because
Where's the?
It was the
You
same.
received the trial court record?
Yes, Lord, we had seen, we have gone through and.
Because last time the order was that
My learned
you
friend,
had not been provided.
my learned friend did.
So you've received it. Yes.
But, yes, we tried, Milord, on 25th, we had filed the return submission, same, Milord. Where, Milord, I crossed the Nepal border, which is just at a distance of 20 meters. And, Milord, I was just taken in custody in the evening itself and wrongfully confined on 5th itself.
There's no endorsement.
No,
Let him complete thereafter.
Lord, endorsement may see now the passport as my lord has asked for the original passport.
No, but the original passport is given.
This Lord, it's only the Nepal immigration stamp is of 5th.
No, but if there's no immigration stamp for the
India, that is what, Lord, because I was taken into custody wrongfully confined.
into custody, he has
You will
to
have
produce
to
it.
come into the country before you're taken into custody, is it not?
Which one? That is what, Milord.
They can't take you into custody without first
That
letting
is
you
what,
enter
that is
India.
what, that is what they have taken now, Lord, how I am in custody, because in the morning they are showing that I
I
am.
don't know how these immigration offices work there.
That is what, because I,
Nepal is considered to be the most porous border. That's
Lord,
why everyone comes in through Nepal.
Lord, I may point it out. I did not allow, I was not taken into wrongfully confinement, Milord, in the Lord, in the no man's land. That is what their case is.
Date you said?
5th of November, not page.
5th of November?
2016. Lord, I crossed the Nepal border. Lord, the immigration stamp is there. Then it is their case that.
One moment, let us just see the entire passport, because you have 2 visas from India also last time we know.
That's Lord, the one is a valid visa.
29.
At page 29 is the valid visa.
5th of November, is it?
5th of November, page 11
You keep
of the
going back
passport.
and forth of this.
Yes, my Lord, I am with the business visa, my Lord. I am.
He's going back and forth.
Lord, it is a business visa with me.
Well, Nepal. According to you, where did you arrest him?
Page 130 is the site plan. 130 of the trial court report.
Page?
One,
The
one,
record.
130. One trial court report, 130. The site plan.
130.
I arrested him at the SSB checkpost. Inside the India.
130.
130.
There are no pages.
Lord,
There's no running pagination to begin with.
Lord,
Pages.
my learned friend must be referring the trial court record.
Trial court.
Trial court record.
Trial court record, my lord.
Trial court record, 130, page number 130.
How do you find it? There's no running pagination.
Lord, it is after, Lord, it is, I mean, point it out, after 173, again starts with 128.
Index item 22. Index item 22. Page 130. Full. Index में देखिएगा पूर्ण से बात.
It's the copy of the passport only, 188, 189. This part of it is in.
Lord, may see page 195, trial court record, on the top handwritten.
195.
22.
And Lord, this, as per the story and the side plan is all different.
Page do you want us to look at?
130, 130. That is on the PDF.
No.
No.
The
original.
This is running in pagination.
No, you're seeing it from the
another paper.
Trial court record. Lord, I am referring, Lord,
one might be.
it's exhibit, Lord, exhibit K5. I'm sorry, Lord.
130. 135.
130. Side plan. He has been arrested inside the India, not in the no man's land.
130.
Yeah. Item 22, ma'am.
130.
Item 22.
130 of the, Lord, the typed copy. Translation.
What is SSB check post?
Inside the Indian.
Oh, what is it?
Seema Sashaktra Bandi.
Seema Sureksha. It's a chain.
But where is the immigration post then? That's the immigration. Immigration is also SSB.
No, my lord, immigration is different. That is what, my lord, day before yesterday I was seeing the satellite. It is, my lord, just this one, 200 meters inside from the no man's land.
Place of occurrence, India Gate.
So before you caught him in the no man's land.
No, inside the.
Let's look at the FIR itself.
How do you arrest him without at least putting the immigration stamp for him to enter into India?
So you say that place of occurrence is A. That is before the SSB check post.
Near
the SSB.
Near the check.
Place of occurrence,
So
India Gate.
that is on no man's land. You are
No.
Because you put the gate also. The picture of the gate is there.
Oh,
so
this police check post C is India's check post.
Yes.
Okay. Then how did he get in without stamping?
How do you arrest a person if he's not even in India?
No, he was in India.
He is not in India in terms of the passport. There's a Nepal
That is what he said.
departure stamp there. There's no entry stamp on the Indian side.
See, if you caught him on the no man's land, definitely you should produce him before the immigration authorities and get his passport stamped before taking him inside. Now you say that he was inside India, and that too very near the check post also. So it is not a not as if he did not pass through the check post. If you say that he had come through the check post, then definitely it would have been stamped.
And this, according to you, happened on 6th.
6th.
How is that possible? He left on 5th. So he slept in that no man's land the night.
He left Nepal on 6th, but there is no entry of the on 6th to enter into the India. See, there is nothing on record.
I hope you are understanding what we are trying to tell you. See, if he has entered India on 5th or 6th, whatever it is, his passport would have been stamped. So the possibility is that he was arrested in no man's land, and you did not, probably seeing that he was in police custody, the immigration officials would also have not been very careful. You ought to have produced him at the immigration council and got it stamped if it was in no man's land. Now, when you say that he was in India, then how did he get inside India? Passing through the check post.
Whatever the record.
That's all. We can't.
Whatever the record.
We can't.
And Lord, the FIR says no man's land.
FIR says no man's.
No man's land.
Then you.
FIR also says no man's.
That is what will may read the fourth line in the page 31 of the typed copy, translated copy. Will be
in the record or
record. Trial court record. This one. Trial court record in a type. There is a different.
31.
Page 31.
Page 31. Type 1, my lord, the translated version.
Yes.
May see, my lord, the fourth line. Third line starts, I, the Sub-Inspector Rajpur Singh, while checking suspicious persons vehicle reached at the main India gate situated on the India border on the no man's land. Under Sonali.
In the India border on the near, not on
East side of India Gate.
See, no man's land is not within India. Please understand that.
Yes.
There is always.
But border is just to enter. When you enter, there would be a border.
Council, we are asking you two things. If you had arrested him within India, as you say, just before India Gate, he would have passed the immigration. Then he would have stamped his visa. But if you arrested him no man's land, you should have ensured that his visa is stamped. That also you didn't do. So then the only thing is some hanky-panky.
Whatever we got, whatever.
But how do we sustain your entire exercise if this man is not shown to have entered India at all?
Whatever records I have.
And this objection was.
That's the reason as to why we have all this procedure, is it not? Immigration, everything. You, according to the FIR, you picked him up in the no man's land.
Right.
These the men India did.
A foreign national was entering India from the north direction, stopped by the SSP force.
At around 7
So therefore, you, and on the earlier part, you said that it was on no man's land. You specifically said so.
Why child sexual? Because you check was for the situated on the border, on the no man's land, but he has been arrested.
You cannot arrest him
At
without
around
at least
7 a.m. in the
putting
morning.
the immigration stamp to show that he has entered India. When he's in no man's land, he's not in India.
May I read further? At about 7 a.m. in the morning, a foreign national was entering India from the north direction towards Nepal in the south direction. On the basis of suspicion, that foreign national was stopped by the SSP force. And while searching the bag and belongings, it was found that he was hiding illegal hashish in the bag.
See, also your FIR says no man's land. You arrest him. If you have to bring him inside India, you should have produced him before the immigration authorities and stamped the passport.
Nothing on record. Whatever the record.
That's the right way of doing it.
This was not the first time raised. The very first opportunity this was objection was raised. Lord Macy, page 230 for the trial court record.
The same volume.
230 of the trial. Lord, there are different files. One is a translate this one as it is the trial court record. That is below at page 230.
From handwritten.
With the handwritten it is 230. Where the letter is there, Lord, and before that it is below the. Lord, what very important 229, and I put the typed copy also. Lord may see this just 3 lines. Lord, and the order also says the honorable judge was not there when the charge sheet was filed, and that is what Lord it corroborates with the what he has said it on this date.
Say in the FIR that there was a dog, you don't.
But dog knows to procedure around about 23 lakhs. The which we had cut, there is cost of 23 lakhs.
That is a different matter altogether. What we are asking you is, when you record an FAS, you should say the entire things, that he was coming with a dog and all that. If at all it has to be done. 23 lakhs, see, in the border, you have no difficulty in getting such confinement. If somebody brings in 3 kilos, you keep some for the other purposes. We all know what's happening there also.
But in addition, then because of dog, because of dog, we have fabricated but a person.
Also, quite enterprising people, your officers also.
Where was he coming from? Nepal?
From Nepal, Lord, that is
Nepal, which place?
Sonoli border. Coming from Nepal, Nepal side towards
Stamp.
Stamp is of this one Sonoli before the Sonoli border.
L-BHA.
That is not the immigration Nepal is. That is Nepal immigration. They are not specifying the place, but it is same, Lord. That is what in the morning they have shown me arrested in the morning. He had come by bus. That is what the bus ticket has been filed. And Lord, this letter which I am showing at page 230. Lord,
Judgment.
Lord, for a moment. The judgment, Lord, as far as that entry is concerned, this is a minor contradiction because it's an admission by PW1.
What is the other evidence that what you call dealt with? You have already told us about the entry in this thing. What is the other evidence dealt with in the judgment?
Other evidence against B. There's no other evidence. That's the only the statement of PW1, 2, and 3. And that is also contradictory.
Let us see PW 1, 2, and 3.
Please, Malad. Add annex the typed copy also. Milord, may I just take it to the Hindi version, Milord? That would be in the Milord which we have filed before this honorable court.
English version also is filed. Is it not?
Sorry?
English version is also filed.
Unless there's a specific portion which you need to show us in Hindi.
That's it. Milord, in fact, my marking is because
61 for the trial court report. Page 61.
Sorry?
Page 61. From
Of the
file
SLP.
SLP.
Trial court report.
trial court.
Page 61.
SLP also it is produced. Tell us where it is.
Complete deposition necessary in the trial.
Complete deposition is page 61 of the trial court report.
Milord,
51 is the order.
61.
61, Milord, is the
61.
You have produced PW 1 to 5 in annexure P4, correct?
Yes, Milord.
That is the
Yes, Milord, I had annexed, but it is the High Court translation, Milord, it is at page.
High Court translation.
It has page 61.
You have gone through it from page 42 onwards. It is there. Correct.
The dates incorrect in motion.
There's so many people around him and he doesn't. See, we are looking at that file. Your SLP file.
Yes, Milord, I may.
Look at annexure P4.
Yes, Milord.
Dates are correctly mentioned in the page 42.
42 onwards.
Incorrectly mentioned. 1/5/2014 is 1/5/2017. 1/5/2014 is written down. It is 1/5/2017.
Page 40.
1/5/2017. Oh.
Page
Let us
42.
read that. Let us read that. Just wait.
Yes, my lord, it is.
We'll read that. We'll read that.
1/5/2014.
17.
17.
There is
Here
a,
at the top, it says 1/5/2014.
that must be a mistake.
Correct translation is page 61 of the trial court report, correct translation of the PW1.
No, it can't be, sir. See,
It must be
the
17.
2000, the one special case one.
Yeah.
Then it's given before court, correct?
Yes, my lord, that is.
Okay. So PW1 SI Raj Prakash Singh did not see the contraband being recovered from him. By the time he reached there, everything was recovered. Wait, this is not PW1.
This narration, most of these cases, this is how the IOs give evidence. As if as soon as the accused sees a police officer, Harish Chandra takes over him and he speaks the truth. And he says, I have bought hashish from so-and-so, I have brought it to sell. So they confess everything and they say, we trust you. The police also need to be a little mindful of how they give evidence, isn't it? Are we supposed to believe that as soon as they see a uniform, all accused start quaking in their shoes and tell the truth straight away? Or is it after you give them the treatment?
See, he was accosted by Inspector A. Rajakumar, Constable Vinod Kumar, Constable Yug Bahadur Gurung.
Are they examined?
Are any of them examined?
Raj Prakash Singh.
Raj Prakash Singh was in the other part.
Yes, ma'am.
All they have been examined.
Vinod Kumar is the
Examined.
Vinod Kumar is
PW2. Let us see.
A Raja.
Wait,
Lord A. Raja.
wait.
Vinod Kumar, Head Constable SI A Rajkumar, SI Leptesh Yadav, IO.
Wait.
Vinod Kumar is there.
There is a minor distinction.
Was not covered.
See, it is after the recovery that you search each other. That again is.
Where is Raja Kumar or whatever his
PW3, my lord.
PW?
My lord, he says I was present at my office residence. So he's, in fact, all three people are not the witnesses of recovery. Three people have been taken as witness of recovery. All three are giving different versions. And none of them have claimed that the church has been recovered by them.
Their statements are also not gelling.
A. Rajkumar is there.
A. Rajkumar is.
Page 56.
But what Rajkumar is supposed to have said at page 44 is different from what Rajkumar himself says. The consent letter at page 44 ending.
44
ending. Dog will have to go. You will have to advise your people to be a little more.
Do one.
Not minor contradiction.
All they have, all
minor, not minor.
because of timing, which we
No,
I
no
look at
immigration entry.
I would have,
nothing. Less than the better.
with this point.
See, first thing you would look at a foreign national is a passport. And if he had not entered it, you should have gone there and got it entered. That you didn't do. You caught him near the no man's India gate. Then if he had not entered.
And immigration stamp in Nepal would have been put when he was leaving the border. They don't put it in Kathmandu and send him on a bus. The immigration stamp would be put at the border when he's crossing Nepal. So if he did that on 5th, he obviously must have come in on 5th. Less said the better about
where he went, I don't know.
And all the witnesses talk about the dog. If it was there, you should have specifically mentioned it in your Mahasar also. Don't do all of that.
Arguments concluded, judgment is set.
Give it.
Well, the written submissions also have been giving each and every point.
Your dog was how old when you lost it? What
What
have you done with this dog? Vaira? He named it also, he gave it also an Indian name. He seems to have been in India most of the time.
Because of dog, he is not firstly implicated. Because of dog, he was not.
You liked his dog, that's why you caught him.
23 legs of the top.
Indra, don't tell us all that. Enterprising people, they catch on the daily basis.
Deeply obliged.
21.
Madam, send me the reports also.
I'll support it.
That is over to the after this.
Though the caption is for final disposal.
Yes.
I don't remember giving such a direction myself. So is it a carry forward from someone else who directed that?
Okay. Honorable Justice Sanjay Khanna.
Oh.
Then my lord's
While I was with him.
Yes.
Probably that's how the matter follows, your lord.
20th September 22.
Very.
20th September 22.
20th September
2022. Released on a non-miscellaneous.
Non-miscellaneous day. It doesn't say final disposal.
Yes, doesn't say final disposal.
And on that day, I wasn't with Justice Khanna.
Oh, yeah, that's another thing.
That's right.
Maybe 25th April.
25th
For
April
final
is
hearing.
for final hearing
On that day also, I was not with you.
Yeah.
Very good. I mean, after that, 26th March, it came before us and was adjourned. So there's a arbitration award.
Yes, ma'am. Award in my favor, 34 in my favor, barring one item. And then, Millard, from 37, it's been completely reversed. Not even as an appellate court, but as if it was a trial court in my humble submission. And it's been said when the award runs into more than 300 pages and voluminous evidence has been incorporated into that one.
The award is set aside in
Yes,
its entirety.
Entirely. Even admitted amounts. Earlier on more than one occasion, Millets, written submissions were filed by both parties, it seems.
You don't have any written submissions by the looks of it.
And there is a convenience
The only
compilation.
one of this
Convenience compilation is there. Written submissions are also.
written submission. Oh, there's how many volumes?
Runs into 7 volumes.
7 volumes.
Yes.
So matter for leave there.
Filed earlier.
7 volumes, not for
But written
miscellaneous.
submissions were filed in 2021. Now new judgments have come. So which I am
And
relying.
my lord judgment was the last week's judgment, which encapsulates all the legal position up to that point in time with regard to the scope of 34 and 37. That squarely answers all my pleas here too.
No, but if you have to take us through so much material, we'll need to hear you on a regular hearing basis. Not
We have
like-
already been there for so many years, millets, waiting for the award.
There are others
For
also
the
who
fruits
are
millets.
in the queue. Is it
Completely
not?
give us two concurrent ones millets. And then we have filed a convenient compilation as well.
Matters which are capable of being disposed of quickly, we can take up in the miscellaneous here. Not matters where there are 7 volumes to be gone through.
That can be disregarded, millets.
No, how can we disregard it once we file it? You can join the queue list.
Millets.
We've
We have just filed convenient compilation encapsulating whatever is essential.
We've granted
Without-
list for hearing in the list of regular hearing matters on 15th April.
15th April minutes.
Once you join the queue, you'll have your turn.
Grateful.
Can we pray for March minutes?
Hardly a judicial time.
Yes, we had been waiting for a decade.
15th February will come only in the.
For something in the alternative minutes, without granting leave, could my lords hear that matter any Wednesday or Thursday minutes?
It's better that we grant leave so that you join the queue. There are people who are waiting patiently. How do
And
we justify
my money,
you jumping the
it's
queue?
my money admitted and.
Whatever it is, you'll have to join the queue.
Great, okay. We're always fine for 5 minutes.
22,
Millets will file our submissions, millets written submissions.
very well, written submissions may be
Yes.
filed.
Yes.
Your Honor, item number 22.1, I have not received the copy of counter affidavit they have filed. Even as per the office report.
Yesterday, there was one counter which was given, which is deposed to on 27th October 25. But it was given yesterday night during circulation.
I'm so sorry, Lord, but in fact, the other counsel, I gave it the copy in the court itself. I'll again give.
You have this.
We have not received.
27th October.
No, Your Honor.
You don't have that.
Because I have filed a counter in one case, my lord, I am adopting it in all.
No, but he's not.
I'll give you. I'll give.
If the previous one is adopted, I have received that.
Which one?
That's what I said.
That copy I have received.
27th October.
On
Previous copy I have received.
Yes, on the earlier date itself, I said
No, but this copy was given to me last night during the circulation. I don't know why it came.
But we had filed it, my lord, on 27th of October itself.
Because the email perhaps attached to it says 27.
Yes.
But yesterday it came late last night.
Must be some mistake in the registry, my lord, because we had filed it on 27th.
Well, you've received this copy. This is
Yeah,
the only
previous
one.
copy we have received.
You need to file a rejoinder to this.
Yes, Your Honor, I need time to file the rejoinder.
So, counsel for the petitioner. Petitioner,
is,
it's time to file a rejoinder to the counter affidavit dated 27/10/2025. Equal in that regard shall be done within 2-3 weeks based on 19th March. 23.
The Lordship, I am seeking the short passover in this matter.
Password.
Okay.
24.
My lords.
You're supposed, what happened to your applications before the High Court?
Because the High Court for some reason is not taking it up. Because I will ask them also, I had requested. I think they are worried because of the pendency of the SNP. The Lordship will direct them to dispose it off in 4 weeks.
Said so, perhaps.
I think that order I was seeking last
We are
time.
informed that pursuant to our order, the petitioners have filed applications before the High Court. They seek some time to enable them to pursue the matter before the High Court.
It's,
What more do we have?
for some reason, he's not taking it up. We'll just give a request the High Court to dispose it off within 4 weeks.
Applications have been filed before the High Court, but the same are not being taken up. Perhaps under the misconception that the same need to await the result of the special petition. We make it clear that pendency of the special petition shall not preclude the High Court from considering the aforestated applications filed pursuant to our earlier order dated 6/2/2024.
But the
List
making
on-
little time bound, my lord.
Any specific date?
We can't
Well,
directly.
leave it, I leave it.
We made it clear that this
Yes,
SLP does not preclude the High Court.
I'll press upon him to dispose it of.
Yes.
In fact, I have said that it's a nullity and abated minutes, so he should.
List on 15th. Meanwhile, you pursue the
Very grateful.
Petition number
Very
has to be substituted. Application is there.
application is the substitution application.
Because I filed it here by append and caution, but actually
Very
because
well.
he had died in the High Court, so I moved there.
Wait till-
Yeah, I moved there, minutes. For setting aside the abatement and also.
25.
Service is incomplete upon the proposed LRs.
No alternate address is available. I will take steps to, if I treat the service through alternate mode.
Office report dated 27/1/2026 reflects that service is incomplete. So far as proposed legal representatives number 2.3 and 2.5 are concerned. Joint counsel for the petition can take necessary steps in that regard.
Like yesterday's matter.
List on
Expert opinion.
expert opinion. List on how much time do you require?
2 weeks.
23rd.
26.
My lords, this is an SLP by the government where there are 3 orders against me, no doubt. However, my lords have given an order of notice and status quo, and I'll point out to my lords how the errors are corrected. My lords, this issue relates to a parcel of 1.45 acres of land. There was the predecessors of the present respondent originally owned 5.79 acres, out of which 4.34 was undoubtedly, admittedly acquired in 1957. The present issue, my lords, deals with 1.45 acres of land, which it is the government's case, my lord, was also acquired in 58, and we have sufficient documents to prove it. Now, my lords, be that as it may, because certain documents were produced belatedly, etc., I will come to that later. The point is that in 2001, an original suit comes to be filed seeking a bare injunction for rectification of revenue records. It is asserted in the suit that the respondent herein has been in continuous possession of this land since 1958, pursuant to an acquisition of a certain portion of it. This present 1.45 acres has remained in his possession. However, to support this, the fact that he is asserting, not a single shred of evidence is placed to show his continuous possession. No revenue receipt, no proof of cultivation, no nothing. And my lords may then see that in this suit, how it is decreed, my lords. My lords, the decree starts at page 82. And my lords may just straight away come to the issues at page 87, my lords, in a suit.
Yes,
My lords have that. May I read the issues, my lords?
there are no issues there.
Yes, my lords. This is the first stage of perversity. My lords, the state is not at all blameless. We have been remiss in certain documents. But when a plaintiff files a suit and makes an assertion, he puts forth a fact. He has to put forth documents to prove that fact. Accordingly, the trial court will frame issues, my lords. And what are these issues, my lords? May I read? In my humble submission, the first issue ought to have been, has he proved his possession? But nothing. Based on these issues and based on bare averments, this suit is decreed against me, saying since he says he is in possession and he was at one point the owner, and the government has, and in fact, my lords, the owners, they shift to the defendant to say it is on the government to show that they had acquired the land.
No, but if you claim that it was acquired, the burden would be on you to show.
My lords, we do not claim. It is our revenue record which reflects it is government land.
The revenue record itself
Yes,
reflects that it was acquired.
Suit. for a mandatory.
Reflects the details of the acquisition.
No, my lords, but it classifies it as government Porambok land.
Very.
So now when the plaintiff files a suit seeking a bare mandatory injunction, this is not a declaration suit, it is a mandatory injunction to rectify the revenue record. It is for him to prove that the revenue record ought to be in his name. And my lords, to do that, what are the two elements? First is title, second is possession. The Honorable, the learned trial court ought to have looked into it. They do not frame a single issue in this writ.
Suit is decreed.
They simply decree it. And based on the fact, because they shift the onus on the defendant to prove that he is not the owner, which in my humble submission, my lords, is not what is envisaged in such a proceeding. Which starts, the starting point for which, my lords, is a revenue record classifying it as government Porambok. Second, my lords, there is no prayer made for declaration of title in the suit. However, it is decreed holding him to be the title holder and the possessor, and therefore a mandatory injunction for rectification of revenue record is given.
Decreased title. Then you filed an appeal.
An appeal, my lords.
How does the appellate court deal with it?
My lords, the appellate court, unfortunately, now we can say in some way that the burden has shifted to me. Yes, my lords. My lords, the plaint, my lords, will find it at, my lords, page, it is page 70, my lords.
70.
Page 68 it starts. I can take my lords through it. My lords may first have page 70. My lords may actually just have para 3 at page 69. These are the bare abundance, my lords. May I read, my lords?
69.
Page 69, para 3.
Yes.
The plaintiff's ancestors, including his grandfather, late so-and-so and father so-and-so, owned and possessed an extent of acres 5.79, inclusive of plain schedule land in RS number 255/225/3A, black cotton soil cultivable land as per entries in the revenue registers of the then Belfara Taluk and also subsequent records. During the minority of the plaintiff, after his father's death in the revenue records, the plaintiff's name was entered as owner and Pattadar, represented by his mother and guardian late Budimma, who was continuing in possession and enjoyment. After the state of Andhra Pradesh was formed, an extent of 4.35 acres was acquired in the year 1957 by the defendant for Budameru flood diversion channel out of the said land of 5.79 acres, leaving the plain schedule land for the plaintiff, which is continuing in his exclusive possession and enjoyment as of right. The plaintiff does not own or possess any other land anywhere in the country. While so, the plaintiff learned during the year 2001 that the plain schedule land is noted as government Porambok in revenue records, though he has been actually continuing in his exclusive possession and enjoyment as his own private land as per the settlement register also. It is submitted.
Schedule is not finished. Schedule is not there because there is no declaration.
May I make a suggestion which will perhaps save some time?
For the 5.7.
What is the suggestion you want?
Yes, my lords. My lords, one of the reasons the trial court perhaps non-suits me is that I was not able to show the produce the full record of the acquisition of this land. My lord, subsequently I have got it. I've tried to produce it before the High Court, but then the High Court has gone on a misconceived understanding of Indore Development Authority and says you have not shown compensation, hence anyway you could not be hold title, which is obviously wrong.
Which paragraph is that?
Of the High Court minutes. My lords, my lords may have page 27. My lords may have page 28. Sorry, page 27.
27.
Yes, ma'am.
No, let us
My lords, towards the bottom of the page.
27.
Yes, my lords. About 12 lines from the bottom, my lords, as one could see from the pleadings. Do my lords have that?
Yes.
As one could see from the pleadings, the oral and documentary evidence and the judgments of the child court and the first appellate court that there is no material to show that government paid compensation to the plaintiff with reference to acquisition of plain scheduled land. Even in the present petition, it is not the case of the government that it paid compensation.
No, but where is the reference to the material that you produced?
My lords, the references are throughout. My lords may have page 26, the submission. And then I'll take my lords. We have annexed the material here also. I'll show the material.
Before they are
Page
Support of this petition stating that 1.4 is passed by the land acquisition.
I can take my lords through the documents. We have annexed them here.
What documents have you filed?
My lords, showing our acquisition as well as possession of this land, my lords. My lords, we first have the award, my lords, which is annexure P2 at page 48, my lords.
48.
It begins at page 48. This is the award.
Where is this?
My lords, this is award number 8 of 1958.
Very well.
Page 48, annexure P2.
Where is the reference to this
My
now?
lords. My lords, in the third line, my lords will see acquisition of survey number 225/3A.
Yes.
And then thereafter, my lords may come to page 50.
Yes.
Apportionment, my lords have the heading.
Yes.
Survey number 225/3A, 1.45 acres. This belongs to Koganti Jagannath Rao. It is his ancestral property. It has come to his.
Who is this Jagannath Rao? He is the person.
He is the predecessor of the.
He is the plaintiff. He is the plaintiff one.
He is the plaintiff himself.
Plaintiff in the suit.
At page 50, slightly see the second paragraph also. Second paragraph in page 50 minutes. This document is not part of the record, but however.
Yes.
This is another survey number.
Yes.
227/20 dash.
No, my lord. This is 225/3A. It says.
This is one. The next paragraph is 227.
My lord, I think the respondents council is talking about the second para in page 50 at the top, my lords. It says all the lands except RS number 225/3A were taken possession by PWD on 1/9/57. And hence interest will be at so and so. So, my lords, as I had indicated earlier.
So possession was taken prior to the award. So therefore.
No, my lords. No, my lords.
No, not this land.
Yes,
The other.
the other land had a separate.
Therefore, you say that for those lands, interest will be paid, not for this land.
Yes, my lord.
Because possession was not taken.
Yeah, that is other set of lands, other portion of this land. And then place it in the context.
Let us see what he has to say. Yes. To begin with, your suit relief itself is unheard of. Mandatory injunction to rectify the revenue record without first asking for declaration of title, no proof of title, no document file, nothing, and the trial court gives you a declaration of title. You don't even pay court fee for it. So you pay court fee for a rectification by way of a mandatory injunction. And thereafter, there is evidence now to show that this land is
Yes.
acquired.
My lords, may I just
Even
make a
if,
suggestion?
even if they did not take possession,
We did.
once it is acquired, it is acquired. You have a right to ask for compensation, that's a different issue.
They never acquired this land, my lords.
Well, there's a mention of it, this award is there.
No,
Who says that the entire, out of entire property, just a portion was acquired? You say that in your plate.
no, my lords.
Out of
You
5.7.
admit the fact that
That is a different acquisition.
No, no. Whatever
where
it
is that
what is
document? Did you file it?
You specifically say that out of a total 5.79 acres,
Yes.
4.45 was acquired.
Yes.
And the balance remained with you. That is your specific contention in the plaint.
Yes.
Who has
No
to
document
establish that?
Yes, my lords.
No
Who has to
document
establish
filed.
that?
No, my lords.
Along with your plaint, did you file a copy of the award in relation to that 4 acres, 35 cents or gungas or
There is-
whatever it is?
With the government and me, my lords, there is no dispute, my lords. Even the government is saying so.
What is,
You approached the trial court for a relief, you
No,
need to substantiate it, is it
My
not?
lords, may I specify something?
Where is the evidence to show anything at all?
My lords, may I?
And on what basis do you secure a declaration of title in a mandatory injunction suit?
My lords, may I clarify one thing, my lords?
the High Court seems to have proceeded on the basis that they have not proved their return statement. How can that be?
No, it is not on that basis, my lords.
That is exactly what the High Court
Paragraph
says in
29.
para 29.
If your lordship sees the original plain that I filed, look at my specific amendment, my lords. For all throughout, from all times immemorial, my lords, the revenue records always showed my ancestors, later my father, and thereafter me as the possessor of the land. Land acquisition happened only with regard to a particular extent, my lords. Now,
Plaint is completely direct of.
lords, only one particular revenue entry was added in my thing, showing it as an approach road, not government land. My lords, explain one thing.
This decree cannot stand.
My
May I
lords,
explain one thing?
suggest, my lords, my evidence was not before the
Why
court.
do you want a remand, madam? Yes, and why?
Because, my lords, none of these documents are part of the records. It's a civil suit, my lords.
Your prayer itself is misconceived.
Lords,
And the relief granted to you is worse.
Lords, revenue record, why can't it be corrected? Because they mention it as an approach road, not government
We
land.
need
Your own
for
It is not
to
government land.
maintain a suit for rectification of revenue records.
Yes,
You need to have something more than your mere ipsy dixit.
no,
Nothing, no documents whatsoever to
my lords,
prove your
look at the documents that I filed, my lords.
What did you find?
Kindly see, my lords. Look at the exhibits that I filed along with my EA, my lords. The printed detail
Some
of the,
registered holders,
the
they don't know
resettlement
what that is.
the
Who is
resettlement-
examined to prove that?
my lord, the MRO is examined, my lords. He himself is admitting that it is my land. The MRO says, yes, they are the ancestor property of this Pata land, and we have acquired a portion of it, remaining remained with them.
And none of those documents are referred to here.
If your lordship sees my,
You don't produce any of these documents along with the,
where, my lord?
where do you refer to these documents here? In the plain.
This
Plain is hardly 2 pages.
plain,
Claim injunction to rectify.
yes, my lord, but it has the resettlement register, the revenue map
Where
of the
is the
village.
mention of it though?
The exhibits are mentioned there, my lord. May I show the trial court judgment, my lord, where it is referred to?
You've just, list of documents is one thing. Where is the plain pleading?
Nothing in it.
There has to be an averment in the plaint, is it not, to support the evidence?
Can you plead
My
evidence?
lords, the fact which the defendants themselves are admitting, my lords,
What, sir?
it's not about me, my lords. Even they are saying it is in the revenue record, it is their own land. If, my lords, when they are saying 5 acres is my own land, my lords, where is the question of me again admitting it, my lords? If the
Challenge in this appeal is to the judgment dated 7/11/2022 passed by the High Court of Andhra Pradesh at Amravati in second appeal number 1186 of 2011, confirming the first appellate court judgment of the learned judgment dated 5/3/2010 of the learned 7 Roman 7 additional district and sessions judge within brackets fast track court, Vijayawada, in AS number 87 of 2009. Thereby, the first appellate court confirmed the decree granted by the learned first additional senior civil judge Vijayawada in OS number 851 of 2002. What is the date of the trial court decree?
My lords, the decree, my lords, is 15/3/2004, my lords.
15/3/2004. We find that the very substratum of this entire litigation, namely the suit on which it is founded to be defective in its very foundation, in its very inception, the said suit was filed by the respondent herein. Which respondent?
The deceased respondent, my lords. Respondent number 5 who is deceased, my lords.
Respondent number 5 here.
Deceased.
Why is he shown as respondent number 5 if he was the sole plaintiff?
My lords, these are
And the state government and the government deleted him, my lords, from the array of parties.
my lords may have page 33. The LRs are 1 to 4.
One Koganti Jagannatha Rao,
Then
whose
he's the-
LRs are 1 to 5.
No, but some Muslims have come in. I don't know what is happening. Who are these R1 to 4?
Lords, I am R3, lords, they are subsequent purchases of a portion of the land, my lords.
Was filed by respondent number 5.
Deceased respondent.
Deceased respondent number 5 herein. Koganti Jagannath Rao seeking a mandatory injunction for rectification of the wrong classification of the suit schedule land in the revenue records by changing it into patta land by showing it as patta land instead of government forum book. We find
No, my lord, not government forum book, my lords, it's shown as road approach, my lords.
we don't know what your prayer also is neither here nor there.
My lord, it's shown as road approach.
As patta land is showing it as plaintiff's patta land, showing it as the plaintiff's patta land. In effect, the plaintiff, the deceased plaintiff seems to have wanted a declaration of his title, but skillfully molded it as a suit for a mere injunction and paid court fee accordingly. However, the trial court, where is that decree? The judgment of the trial court?
It starts at page 82, my lords.
The last portion.
My lords, the order is
The trial court,
93.
surprisingly, did not even bother to frame relevant issues and merely frame two issues. That is, one, whether the plaintiff is entitled for mandatory injunction as prayed for, question mark, and two, to what relief. Having stated so, the trial court then went on to give a declaration of the deceased plaintiff's title by holding that the plaintiff was the absolute owner of the suit schedule property and that he had gotten right title and interest over the suit schedule property. The declaration ought not to have been granted to the deceased plaintiff in a suit of having lost sight of this fundamental aspect. The first appellate court and the second appellate court deemed it appropriate to confirm the said judgment and decree. We are of the opinion that as the very judgment and decree of the trial court are unsustainable on fact and in law, the superstructure built thereon must necessarily collapse. The appeal is accordingly allowed, setting aside the judgments, all three judgments. The suit shall stand dismissed. Dismissal of the suit shall, however, not preclude the respondents who seem to be claimants under the deceased plaintiff to seek appropriate relief if they so choose before the proper forum in accordance with law.
Yes, may I also record my statement, my lord, that the defendants in their written statement admitted my title, my lord.
We don't need to.
Your Lordship, may I mention item 113, Your Lordship, as far back as in October, Your Lordship had said that the suspension be heard.
It will be there tomorrow also.
Yes, Your Lordship.
Today.
I'm the only person, Your Lordship, and conspirators who still
We've already
engage.
heard you on this aspect.
Item 31, my lords, the Baisakhi matter, my lords, the contempt has been issued, my lords. My lords, we're just seeking some time, my lords. Counter has been filed yesterday, my lords. Other parties are here also, my lords.
Very well. Item 31, learned counter for the petitioner.
For the petition.
Seeks time to file a rejoinder.
Rejoinder, my lords, 3 weeks.
File a rejoinder.
My lord,
the
may I-
counter affidavit filed by
The state and the commission.
filed by the state and the West Bengal. What is that? School Service Commission.
Yes, yes.
School Service.
Lordship, may I mention item 31 and 32?
List on 31 and 32. Both will go to
Yes. 31.
list on. How much time do you want?
Those 3 weeks.
25th March.
Lordship, may I mention item number 35?
32 notice has to be issued.
Notice was issued on the last date.
Notice has already been issued.
Lordship, may I mention item number 35?
What date did I give?
25th
March. Okay.
Lordship, may I mention item number 35? This year.
You wait till the matter is called, please.
So
I'm simply withdrawing this petition. This is a fresh bail petition. I would like to withdraw this petition.
You want to withdraw it?
Yes, sir.
What is your name?
Gaurav Kumar.
Gaurav
Kumar.
Kumar. Ms. Gaurav Kumar, and counsel representing Ms. Ritu Reniwal.
Yes, sir.
Learned AOR for the petitioner seeks permission to withdraw the special petition. Permission granted. The special petition is accordingly dismissed as withdrawn.
Grateful.
Item 7.
Second.
For complaint number 1 and 2.
What is
Amar Suresh.
Counsel. Our core is still unserved. Counsel was there perhaps.
Mr. Diwan is leading, is just coming on because directly go.
Oh, I see, this is that matter where we wanted to.
Yeah.
Lordship, let my learned friend argue the case.
Let me pass out, Mr. Diwan is coming already.
You asked for a password in the morning.
Yes, sir. Yes.
Afternoon, there's no concept of a password.
I don't.
Obviously, you have a stay, so you won't give back.
No, my lord, it's not. I don't mind even in the next week, my lord. It's not that.
Lordship, he is avoiding
Next, no, my.
Take it up next Wednesday.
Next one is okay.
Non-counsel for the petitioner having sought a password, state again seeks a password during the afternoon session. List on next Wednesday's.
Yes.
One issue in that matter, the service is they say that
If you are dismissing it, how does it make a matter?
Obliged.
You want it to be dismissed?
No.
Is it not?
Lordship, obliged, grateful.
You are arguing for dismissal, is it not?
Yes.
Then why do you want service then?
Yes, sir.
Number 23. 23.
Request order will continue.
And then to order. Next.
Please.
Yes. 23.
Yeah, may it please, Your Lordship.
Yes.
My lords, white this.
Who appears against you? No one is here. Ms. Sharda. Anyone? There's no representation for the respondent.
They had sought a Passover earlier.
They had asked for a Passover.
They had asked for a Passover earlier.
Passover, they had asked. I don't remember who asked.
Respondents.
Respondent had asked.
Junior counsel.
Anyone from Ms. Sharda? Anyone online? Keshav?
No, Lordship.
No? No representation for the respondent on second call, despite seeking a Passover. Next Wednesday.
Next one. Obliged.
Item number 27. 27.
Yes.
Circulate the letter. I have filed the
Legal is.
application.
Yes.
It is to be numbered and it is.
You've not filed it till now. You
I
took time
filed
on the last occasion.
I filed it, my.
When the office report says not filed.
Yes, the office report prepared earlier. I have filed later.
Office report is dated yesterday.
Then I have filed the day before yesterday. I have filed it on my work.
May I please, Manoj? It was filed yesterday only.
Yes, sir.
We inform that a legal representative, a petition has been filed to bring the legal representatives of the deceased petitioner on record. The registry is directed to verify and list the same.
My lords, that impleadment application that I've received a copy, may I file a reply to that in the meanwhile?
You want to oppose the LR application?
Yes, my lords. My lords, this is son-in-law who's filing son-in-law of the deceased petitioner.
List on 12th.
Deeply opposed.
Lord.
Yeah.
Lord, item 28, I appear on behalf of learned ASC and Intercommon. Your Lordship is in a part-heard matter, fixed 2 p.m. matter. Seeking a short adjournment, Your Lordship. We are prepared in the matter and learned ASC will ask us to respond to the report.
Lord, this is that matter where there is an inadvertent clerical bona fide error in the form GST1 return. There is no loss to the revenue. It's a bona fide mistake.
They
Now,
wanted to argue it on the last occasion.
yes, my lord, then they took time to file a counter affidavit, then they filed it one day before the hearing. Then, my lord, as a result of that, the matter was adjourned. The counter affidavit, my lord, is that they essentially want to make out a case that the GST system at their end is, my lord, all perfect. Lord, I am an MSME, my lord. I am an MSME and I am suffering, my lord, because I have not been able to rectify my return.
Lordship, there is in fact a Supreme Court judgment
This is
that
my
covers
largest
the case against them. That says ITC.
They said that that requires reconsideration in this
Yes.
order, have they not?
Yes, my lord, this is that very same matter my lordship said prima facie does not lay down good law. And my lordship has already dismissed all the challenges of the revenue against orders passed by the Honorable High
Take it up on a Thursday, that would be a better. 12th February. Based on 12th February.
Much obliged.
The request to be done is done at age 6 in adjournment based on 12th. 29. 29.
This being led by Mr. Sibbal, seeking a passing.
You've not filed a certified copy of the judgment till date. And we find from your application that you don't even say that you've applied for a certified copy.
Yes, we had applied it.
Well, you don't say that. And you say that if directed by this court, then you will file a certified copy. These kind of appeals, you are required to file certified copies. Mr. Sibbal, certified copy has not been filed till date.
Oh, I see.
Exemption application is just lying there. We've not ordered it also. But you need to file certified copies in these statutory appeals. The Supreme Court rules require.
I apologize. I didn't notice it.
Certified copy of the impugned judgment shall be filed within 1 week.
Because the plan is fully implemented. The plan is
certified copy come thereafter. Then even we're not going to look at it without the certified copy being filed. Give a date now. It's on. You said 1 week. No? Next Wednesday. Next Wednesday. Item 13.
Whereas this is the matter which raises the issue of in arbitration proceedings. So I am, my lords, not claiming anything in terms of a payout. Please, my lords.
Who's appearing against you?
Lord, I appear on the other side.
Yes. You'll be appearing online, Mr. Jain.
My lord, unfortunately or fortunately, I have another thing going on. I got caught on the wrong foot. Either if your lordship can have it a little later, I'd be grateful. Because according to us, my lord, the plan is fully implemented and this issue can be addressed in the arbitration. But I mean,
it can't be. My learned friend said it on the last date. Your lordships recorded that the plan is being considered, yet this issue we are seized off
Mr.
and will be
Jain,
decided by
you're
the
doing
court.
us the courtesy of showing us a scenic background. So we take it you're in a vehicle.
No, I'm in a court.
You're in a court, is it? So why are you using this app for the background then?
Oh, I'm so sorry. I didn't realize, my lord, that's not in my hand. Would your lordship just consider having it on another day? Then I'll be able to assist you.
Wednesday, my lords.
Next
Next
Wednesday. We've got a few matters, I think. The Wednesday after that.
Not as the Wednesday after that, I'll be in some.
Then Thursday? Thursday is all right?
Thursday is fine.
Thursday. Next Thursday.
Lord, even tomorrow, Thursday is fine if it suits my lords.
Thursday tomorrow?
No, my lords.
Yes.
Let it be next Thursday then.
All right. Thursday. Next Thursday, not tomorrow.
Grateful. Very grateful.
Grateful. Very grateful.
My lords, may I only, and I'm so sorry. If I may be in some difficulty.
Next Thursday.
Could it be, my lords, that 18th, 19th Wednesday?
19th? 19th is over.
19th.
19th, Mr. Jain.
Grateful, man. Very good. Very.
101. Giri? Where is Mr. Giri?
I think, I mean, 101.2, I just send a word to Mr. Giri, my lords. I think
Just send word to him, one of you can.
because he
start.
must be on his legs, my lords. He had already started the matter. The lordships will recollect, he was in the middle of, yes, the lordship said he had started 101. And just see, my lords, if I can, Mr. Giri. Or may just hold it over for.
Yesterday, a lot of material seems to have been filed. Lot of papers, documents, written submissions, of course, but apart from written submissions, some additional documents. I remember seeing some additional documents.
That must be the lead matter, my lord. I'm in the second matter.
Yes. Written submissions in the second matter, perhaps additional
also how?
additional documents. Who filed the additional documents?
I think they asked for permission to file.
Filed written submissions.
Gary's client must be.
Additional documents. This came yesterday. 28
Convenience
March.
compliance.
Then additional documents.
Mr. Giri, he was on his legs.
Synopsis of list of dates. You've received these additional documents were filed, some memorandum. And along with the convenience compilation also, we have these documents. These are all already on record.
Would it be in
Orders.
In Shakuntala Devi's, your
This
lordship,
is BPCL versus Roshan Joshi.
Yeah. You know, there are essentially two petrol pumps for your lordships.
This is filed by the Council for Roshan Joshi.
Yeah, so that will be in the lead matter.
In Shakuntala case, yes, they have also filed some additional documents. We are not having a copy of that.
101, my lords, that would have been
101.
Mr. Giri's, my lords, I think the AOR would have filed.
Because
Possibly.
I am for the dealer and Mr. Giri, the BPCL petrol pump, so he was leading this.
Yeah. But you're ready to go on with these documents also. We were wondering whether some new document is being filed.
I'm actually in the connected matter, so.
I just assist on this part. Maharaj, the additional documents already on record.
Already on
Section
record.
820, Maharaj.
Then why did you file it along with your
Maharaj,
application for permission to file additional
yes, Maharaj,
documents?
the document is the clarification dated.
Memorandum dated 29/1/21 of the
That's
CPC.
already a part of the SLP paperwork.
That's already part of
Section
it.
820.
Then why file it again?
Maharaj, there was some miscommunication.
Well,
That's why you were instructed.
if it's already on record, then
Yes, Maharaj.
you can start perhaps.
For the dealer, but because the interest is same, so I may start.
So you might as well.
But when Mr. Giri comes and he will, that's why you are not going to
Till he comes, you can tell us what. You are for the dealer, is it not?
I am for the dealer, my lord. So I have filed, my lord, a written submission in this regard. Your lordship may kindly allow me to.
Want us to look at your written submission?
Yes. Well, since this written submission, because the BPCL petition civil appeal was also there, therefore I have made some references to the civil appeal of the BPCL also, so that there may not be duplication of the facts.
You want us to look at BPCL's written submission?
Yes, some more document by me.
Whatever you want, however you want to go about. Yes.
To start with my civil appeal and then switch over to BPCL's documents.
Right.
So far as matter is concerned, this pertains to the establishment of the retail outlet petrol pump in district Dehradun, in a place that is Raipur. It is at the outskirts of the Dehradun, but it is covered under the development area notified by the state government, and Mathuri Development Authority is the local authority in charge of the affairs in respect to the development of the area.
Name of the place you said is
Raipur village.
R-A-Y-A.
R-A-I.
R-A-I. Raipur as in Chhattisgarh, right?
Yes, yes.
Very.
Well, appellant, so husband was employed in the Indian Army, my lord, and in 1999, during the Kargil War,
So you were selected under that quota, is it?
Yes, my lord, because the central government and the BPCL was kind enough to rehabilitate my me, so this petrol pump, the BPCL extended the opportunity to me to have a petrol.
Well,
So,
he was only stepping in for you, Mr. Gill, unless you want to catch your breath and want to take a minute.
Start. Tell us a seat on the right. One reason is my papers are not here.
Your papers are also. Yes.
so, my lord, so after 1999, after 6 years, the BPCL, because the establishment of the petrol pump requires some hurdles to be crossed and some NOCs, etc. have to be obtained. So therefore, after that, this in 2006, a retail outlet was allotted to me, a dealership was granted to me,
Yes.
and that was situated in district Haridwar. It's an adjacent district to Dehradun. And in 2006, it was established. But subsequent, and I operated this retail outlet for about 11. Not sure I may say so here that not even a single rupee was spent by me. So far as the entire investment was of BPCL. The land was not of mine. Land also belonged to someone. So the landlord, that landlord executed a lease deed, as it happens in other cases also, in favor of BPCL, and BPCL granted me a dealership. For 11 years about, I operated that, and 2017, what exactly happened that the land of the landowner, because the widening of the road, the national highway, the NHI acquired that land house. So the landlord or BPCL got something out of compensation or not, I don't know. But so far as I am concerned, I had to close my operations there and inform the BPCL that the petrol pump, the land which the petrol pump was established is acquired. So therefore, I have nothing now. Please, you accommodate me again and allot me some place or allot me some retail outlet again. Grant me and so BPCL had to establish it again. So in BPCL, what BPCL did in this matter is that BPCL asked me that you locate some land, appropriate land in 2017 itself, when the guidelines were not there at all. So
what guidelines? Central
guidelines came in 2020, which is relied upon by the respondent. CPCB guidelines.
When did they come?
Those guidelines came on 7th of January 2020.
Well.
So at that time, 2017, I was just BPCL instructed me just you locate some land, then so that they can explore the possibility of establishing a retail outlet there, and so that a new dealership can be given to me. So far as I am concerned, this was not a new venture for me because I was already operating. They wanted to rehabilitate me in continuation of their policy, so therefore this happened. So in 2017, I made my own efforts in district Dehradun, but district Haridwar, I could not find out there anything. But in Dehradun, I could locate a land that is in Khasra number 1560 in Raipur district.
Yeah.
So, my lord, this land in Raipur district, the landowner is Doval family, the Rajendra Doval, etc. So, identifying a land requires to pursue landlord also. So, I pursued landlord there that you please, if you are interested, you allow me that I can approach BPCL. So, I operated as a intermediary between the landlord and the BPCL, so that there may be some understanding between them, and landlord ultimately agreed in 2018. And what he did, that he agreed, and I moved an application to BPCL way back in 2018, my lord. So the dates and events start from that day.
Yes.
So my lord, I moved an application with the consent of landlord, I moved an application to BPCL that such and such landlord is ready to lease his land to BPCL, and therefore you explore the possibility and you just identify and locate whether this land is worth establishing the petrol pump or not. On 12th of February 2018, my lord. The necessary document in respect of the property in question, my lord, were furnished to BPCL, and along with that, my application to BPCL, my lord. Before that, I request the Honorable Court to see because the dealership agreement of 2006 is Annexure A1 of my civil appeal.
How is that relevant?
My lord?
How is that relevant? The 2006 dealership?
2006 dealership agreement, that's it, second of.
In relation to the first location.
Yes. First location in district Haridwar. So that was acquired, and therefore this is only for the purpose of making a reference to say that what happened. So, my lord, on 12th of February 2018, I wrote a letter to BPCL, and that is Annexure A3 at page number 59 of the civil appeal. And along with that, your lordship may kindly have page number 59 of the civil appeal. So along with that, there is Annexure A4 also. That is an affidavit of the landlord, notarized affidavit, granted by according his consent to BPCL to move ahead in respect of the establishment of the petrol. So, my lord, this contains the annexure photos at page number 60. Your lordship may kindly have that photocopy of Khatani, etc. So far as for the purposes of due diligence.
What happened there?
Thereafter, my lord, BPCL took his own time, and on 18th of October 2018, BPCL moved an application to the district magistrate for giving the required NOCs for the establishment of the petrol. That's the first event that is relevant in this matter. Well, here I may take a pause and say something before referring to this document. That is, construction of the retail outlet requires several filters to be made. So it's not the question of construction of the retail outlet. The decision to locate that petrol pump will be there has to be taken so as to cross those hurdles before starting the actual construction. Here, my lord, may I say something for the reference only, that this NOC by district magistrate itself is a cluster of different NOCs which have been subsumed, which are allowed to be subsumed in the NOC to be given by the district magistrate. And on the basis of that NOC of the district magistrate, because there is a statutory rule, that is 144 petroleum rules. 144 of the petroleum rules provide that this NOC is to be granted because the NOC is to be obtained from a district magistrate. But the district magistrate, before granting the NOC to the BPCL to go ahead with the project, the district magistrate has an institutional authorities under different statutes. So there are few statutory authorities. I will make reference to that also. When the construction is completed, then the last NOC with last certificate which is to be granted, that is the license which is granted by PASO. The lordship is aware of that. PASO is the authority which has to which has to grant the.
Who has to grant?
PESO.
PASO.
PES.
Yes.
Petroleum and Explosive Safety Organization.
And safety of.
Petroleum and explosives.
So that is technically authority.
Petroleum and explosive safety
organization. It covers 4 acts, my lords. It's a statutory authority.
Safety organization. Good.
Independent of the application to district magistrate, there is no other application which is to be moved to anyone else. So this is central authority is the district magistrate. Now, Shuma, can you see now?
We received the other authorities' permission, fire officer.
Oh, no,
Several
that's
letters.
NOC.
That started in 2018.
NOC is to be attached by these authorities to district magistrate and then forwarded to BPCL.
That's correct.
That's what I'm saying. No, yes, that's what I'm saying. This is the central authority, that is district magistrate, who has to collect all these NOCs from different statutory authorities, fire officer, etc. So, my lord, what district magistrate did that? He forwarded the application of BPCL to different authorities, and those authorities, your lordship may kindly come straight way to paragraph 14 of my synopsis, my written submission now.
You've given the table.
Yes, table. Yes, my lord, these are the table. This is the table. Your lordship may kindly say that on 23rd of November 2018, Chief Fire Officer provided his NOC, that is at page number 74 of the Civil Appeal 8042.
Sorry?
Now, now I have shifted to the paper book of BPCL. The NOC is at page number 74.
These are all collected by the DM.
District magistrate, yes.
Very
But these are the mandatory NOCs, which is provided under Rule 144 of the Petroleum Rules. Also, the district magistrate, how district magistrates will proceed within this matter, collect the all NOCs and submit to that. So that he is the nodal officer.
So finally, he grants it on 29th August 2020, according to your table.
No, I'm saying about NOCs. NOCs are relevant here because these are the decisions which have been taken by the.
How do you get out of the CPCB guidelines?
Yes,
CPCB guidelines came on 7th January 2020, you said.
So, so
by the time you got the lease deed itself in relation to this land, those guidelines were operated.
No, our guidelines were operated in the middle of the different NOCs. When NOCs had, 2 NOCs had already been granted.
Very well. But how does it make them inapplicable?
That is what I am saying, because the NOC, the guideline, my respectful submission is that guideline operates. The purpose of providing this tabulation is, the table is that all these guidelines were granted by the statutory authorities and the decisions has been taken prior to the coming in force of the guideline. So it has its consequence for the reason.
What do the guidelines say?
Guidelines say, yes, guidelines say the applicability. Yes, that is what I have said. Mr. Giri is on a limitation aspect also, that these decisions have not, there are 2 aspects of the matter is, if the guidelines have been, if the NOCs have been granted by different authorities. So when this matter came here in the first round of litigation, the issue had arisen who are the necessary parties to be heard so as to set aside these guidelines, the decisions. So as to set aside these decisions, because without setting aside these decisions, the relief can't be granted by NGT, whether the NGT has power of that or that's a
But
second.
why should their decisions be set aside?
My lord?
Why should the decisions of these authorities be set aside? If suppose while this process is ongoing, there is a new set of rules which according to you has no application, but in the event it does apply, then you need to satisfy those rules also. That doesn't invalidate the orders passed by the other authorities in the context of other regulations.
Yes.
Your requirement is not only to abide by those norms, but also these norms which have come in by way of these new rules, if they are applicable.
They are applicable. So my case is
Therefore, you say that those rules are not applicable.
not applicable.
That is a different issue, but for that you don't need to invalidate the NOCs and the approvals given by the other authorities.
Because the NGT is to NGT has to set aside all these orders.
Why does it have to? If suppose there are n number of requirements, A to Z requirements have to be there. If you do not fulfill Z, you will fail. For that, you don't have to get the approvals from A to Y set aside. Because you have to fulfill all of those requirements. If I am within even one, you fail.
If I am within the guidelines, I have to satisfy the guideline, then I have to say whether the guidelines really hit my establishment or not.
That applicability.
That's second
is one
aspect
issue.
of the matter.
But we don't find merit in your submission that all these earlier orders need to be set aside for invalidating the exercise. The exercise can be invalidated even if you fail to satisfy just the CPCB rules, if they are applicable. For that purpose, we don't need to set aside the approval given under the Essential Commodities Act, under the Uttarakhand Road Infrastructure Protection Act. Those are all separate permissions and approvals. Those will not get invalidated or need to be invalidated if you fail to satisfy the norms under the CPCB regulations.
And there is one aspect of the matter is that these are not the decisions in respect of these decisions are to be satisfied. The issue is that the decision has been taken. Now there are the parties before the court. There are not the necessary, and all the necessary parties are not before the court. That's also a question here. My lord may kindly see that if there is a landlord, PESO is there, landlord is there. So the landlord and BPCL has an arrangement in respect of the land in question. Yes.
These permissions are site specific.
To answer this argument.
The permissions under the different statutes are site specific. Therefore, the question of site, yes, if they are site specific, then unless, therefore, the location is inspected, and then after inspection of the location and then verification of the parameters under the different statutes, permissions are granted.
In relation to those different statutes.
Yes.
Therefore, site specific in the context of each of those statutes or regulations.
Yes.
Therefore, if suppose one authority in relation to a particular statute or regulation finds this site to be approvable.
No, not site
it does not
be approvable. There are several other parameters which have to be satisfied under each one of these statutes.
Very well. In the context of those parameters, if suppose approval is granted,
yes,
it does not mean that that approval has to be invalidated if you fail to satisfy another norm in relation to some other authority.
The CPCB guidelines do not source it to any statute.
Mr. Giri, just one question.
Yes.
The CPCB guidelines came in 7/1/2020. Probably you started your procedures in 2018.
That's right.
Obtained a lot of things.
That's right.
If you have established the unit before the guidelines came, you are on velvet. But in the course of the procedures, various sanctions and all that, CPCB guidelines come, then you are required to comply with the guidelines also scrupulously. This is the only issue. If you have not complied, the fact that you started your procedures earlier, obtained the what do you call fire and emergency, this thing, fire clearance, all such clearance, as learned counsel said, senior counsel said, everything has to culminate into the district collector's consent. District collector's consent came only in 29/8/2020. By that time, if the CPCB guidelines had come, you have to comply with those guidelines also. The site specification will also have to.
There is an argument.
These orders need to be satisfied.
A to I conditions were there before the CPCB guidelines came. A to I condition, A to I consents or whatever you say.
Yes.
You obtained up to Y.
Yes.
You did not establish it. Then CPCB guidelines come with one other condition as Z. There is no doubt that you will have to comply with that condition also.
Depending upon whether the guidelines are mandatory and binding.
That is a different issue.
That's what. The guidelines are mandatory.
So this
the guidelines
argument,
are applicable. Sorry.
this argument that NGT has not heard all those authorities who gave various approvals, and therefore the decision is liable to be set aside on that ground.
Not that.
That does not appeal to us.
May not be. I don't think we have to.
That perhaps was one of the arguments sought to be addressed.
Yes. So
that all those orders need to be set
what
aside.
Mr. Raisada was also trying to say, and this we do it in cohesion, is that, my lord, unless these permissions are under different statutes. So the point is, my lord, somebody goes to the NGT and then challenges the grant of the permission that is granted to this retail outlet.
On a specific ground, that it is violative of the CPCB guidelines.
No, that's correct. The CPCB guidelines are citing guidelines. But permissions which are granted by different statutory authorities under different statutes, if they are permitted to remain in force, then, my lords, the retail outlet the establishment of the retail outlet will be valid.
How is
So
that?
unless it is established prior to the guidelines, it will not be valid. See, you will have to tell us essentially as to what are the violations pointed out by them. And if those violations are not existing, you will have to tell us that. And also whether CPCB is applicable or not.
Not only that,
long and
there is
short.
one argument why this is being raised is for a slightly different purpose. And this was raised, my lord, in the first round also. 2018 are when these statutory permissions are granted. Now, the citing of the retail outlet wasn't a challenge even then. Or, my lord, it is challenged, my lord, for the first time in 2020 or 2021. The jurisdiction of the NGT is either under 14 or 15. We say 15 is not applicable for a different reason on a reading of 15 itself. Insofar as 14 is concerned, there is a time frame within which somebody has to challenge it before the NGT. And that is about 6 months from the date on which it is granted. They knew that it was happening. But they nevertheless chose to challenge it for the first time only.
The issue of limitation.
There is an issue of limitation, which is sought to be raised even then.
Independent ground.
Yes. That's an independent.
First, let us look at these CPCB guidelines.
Yes,
and what exactly is.
Yes.
What exactly is the violation of the CPCB guidelines?
So there is also a clarification saying that the CPCB guidelines may not apply in such and such circumstances. But in the context of section,
you try to bring it within those exceptions.
Yes. There is also a contention which has been taken up.
NGT has considered that.
No, NGT doesn't consider anything. That's a different matter.
You raised this issue.
Oh yes. Well, it was
comes-
raised in the first round. It was raised in the first round. We were not. There is an allegation that we
First round?
This matter had reached this honorable court with a civil appeal earlier.
And then went back.
Not went back, Miller. It was stated that they are entitled to file a separate application. And then raise.
It was in 2022.
That's right. This is close of
In
judgment.
that case, the court guided us on this aspect that if the decisions have been taken, those decisions are to be challenged.
That's an observation which is made in the judgment itself.
In the judgment?
Yes.
326. Let us see that judgment.
Lord, I'm sorry.
Yes, Mr.
Let
Giri,
Mr. Raisada complete.
Mr. Giri read that judgment on the last day. The judgment is.
One moment. We'll just go through this judgment.
24.
Yes, 24 years.
That's 2755.
26.
There's nothing about all the orders being set aside.
Yes.
Where does it say? Only on the ground that you were not given notice.
Notice it was set aside.
Only on that ground. All his contentions, that's all.
No, N consents. And K consent is not.
167 of my MP.
N to A to N need not do that. Been established.
Yes,
It is running.
it's running.
When did you establish it? Finally, when did it become operational?
I think 20.
When the clarification came, 1 week before that, petrol pump had
20th
started.
of January 2021.
24th?
20th of January 2020.
20th of January
2021.
Was it in compliance of the CPCB guidelines existing as of then?
On 7/1/20.
No, 2021 as it existed then, was it in compliance? It should be.
We said
It should be.
that's what we said.
It is.
It has not
That's
been,
what we
it has
So
already been
tell us
constructed and
what.
operating.
So tell us what it is. What is the allegation they have raised before the LGT?
So for that, your lordship, so far as the judgment of the previous round of litigation is concerned.
We saw that was only set aside because you were not given notice.
It says so, if that be so, may I read that?
That-
Because there are two civil appeals which I preferred. I am referring to first round of, because this is the third round before my lord.
This is civil appeal number 3755.
1/7/2020. This is it.
Which is that? Where is that?
Lord, if your lordship said my appeal paper book, it's page
17th
151.
May.
161.
Date of the judgment.
Like 28th of January 2022.
28th of January.
January 2022.
The lordship is reading which civil appeal?
You said which?
EPCL or mine?
Your civil appeal.
This is your.
It is at page 206, relevant portion is.
Lordship, put the orders together in a compilation. May I hand that over?
Is a convenience complaint.
That's all. Already we have filed it.
We filed it, Lordship.
I think it's.
Annexure A27, page.
Lordship, I'm carrying hard copies of the convenience compilation. We already also filed it.
This one.
That's right, Lordship.
So we have it.
It's convenience complaint.
Yes.
It's already.
You can lordship, your lordships can look at that. The only problem is that we have prepared a list of dates and submissions with reference to the report. Yes, that's okay.
Which page did you say?
My lord, in my appeal, that's a BPCL's appeal, your lordships, we come to page 161.
This is an appeal filed by Roshan Joshi.
That's
right, Lord.
Roshan Joshi was the appellant.
Why did he file an appeal?
His NGT application was dismissed.
This was the first round, is it?
Yes.
This was on which date? This was on 28th January.
Yes.
After that, you have the later order. This is in May.
That's a second. No, this is one.
May.
This is yes, 107 of the compilation. What is the date of the subsequent order? It's the same date.
That's 17.
Ah, that's it. That's the subsequent. Yes.
That was mine.
All arguments mostly.
You're not there.
Live.
If any decisions have been taken afterwards, after this order, which they say which after this order or after the other petition was filed, his original petition was there. After that, if there are this is what the court says. Proper course would be to permit the appellant to file a fresh OA before the NGT, where he can agitate the issue relating to the alleged violation of the guidelines and also seek appropriate remedy where decisions have been taken in regard to petroleum outlets in alleged violation of the guidelines. So if there is any other decision taken, fine. If he says that fire and NOC was issued with in what you call dehouse the guidelines.
The last paragraph, the court also leaves open the question of limitation.
Well, in this
The
matter,
people-
there was
See,
no.
there is also one other aspect.
See, but the whole problem is your fire NOC came in 2018.
Correct.
There was no way he would have known about it. Only when you establish this thing, that too after the guidelines. If your fire NOC is issued in 2018, is not in compliance with the guidelines, limitation starts only from the establishment, not from the guidelines.
No, that is a moot question which your lordship may have to decide with reference to
that is the whole
section
problem.
14. But there is also one other question which we had raised.
He wouldn't know about the fire NOC in 2018.
This jurisdiction.
How does the provision read? Let us see.
Yes,
This
14
limitation.
and 15 also will have one question which has been raised. This was raised, my lord, at the time when the matter had come up for revision. It was actually raised, sought to be raised before the NGT also. Please have a look at section 15. The proceedings before the NGT can only be in relation to the violation of the enactments which are mentioned in Schedule 1. CPCB guidelines are not statutory.
What is the nature of this guideline?
The CPCB guidelines will are not sourced to any statutes.
No, they must have been issued under some statute.
No, they are guidelines. They are not issued under any statute.
Let us see the guidelines. That's
Yes.
why I've been asking to see the guidelines.
That's correct. We'll take a lot of the guidelines.
Guideline.
But we also, therefore, we took up a contention that 15 is not applicable.
First, let us see the provision, Mr. Budi.
14 and 15. Can I read 14?
Yeah.
The tribunal shall have the jurisdiction over all civil cases where a substantial question relating to environment, including enforcement of any legal right relating to environment, is involved, and such question arises out of the implementation of the enactment specified in Schedule 1. My lord, please cut the chase to Schedule 1 straight away. That's, my lord, after section 38. Water Prevention and Control of Pollution Act, Water Prevention and Control of Pollution Cess Act, Forest Conservation Act, Air Prevention and Control of Pollution Act, Environment Protection Act, Public Liability Insurance Act, Biological Diversity Act. This is when, my lord, therefore, the question of legal right relating to environment is involved. That is the first aspect of it, one limb of it. The second aspect is such question arises out of the implementation of the enactment specified in Schedule 1. The tribunal shall hear the disputes arising from the questions referred to in subsection 1 and settle such disputes and pass orders thereon. No application for adjudication of dispute under this section shall be entertained by the tribunal unless it is made within a period of 6 months from the date on which a cause of action for such dispute first arose. Provided that the tribunal may, if it is satisfied that the applicant was prevented by sufficient cause from filing the application within the said period, allow it to be filed within a further period not exceeding 60 days. Therefore, 6 months plus another 2 months. Relief, compensation, and restitution. That's also important, my lord, because the application seems to be so filed both under 14 and 15, and the tribunal refers to section 15 also. The tribunal may, by an order, provide relief and compensation to the victims of pollution and other environmental damage arising under the enactment specified in Schedule 1, which your lordships have seen, including accident occurring while handling any hazardous substance. For restitution of property damage, for restitution of the environment for such areas as the tribunal may think fit. The relief and compensation and restitution of property and environment referred to in clauses A, B, and C of subsection 1 shall be in addition to the relief paid or payable under the Public Liability Insurance Act. No application for grant of any compensation or relief or restitution of property or environment under the section shall be entertained by the tribunal unless it is made within a period of 5 years from the date on which the cause of action for such compensation or relief first arose. No, my lord, the application for compensation, again, my lord, under section 15, even if you want to avail of the larger period, will have to fall under A, relief and compensation to the victims of pollution and other environmental damage arising under the enactment specified in Schedule 1, including accident occurring while handling any hazardous substance. Fire safety officer, district magistrate, under the Explosives Act, these could all come under these enactments which are mentioned in Schedule A. But when it comes to CPCB guidelines, first it has to be sourced to any enactment which is contained in Schedule 1. And then it has to also relate to an application for relief and compensation.
Let us see the guideline.
Yes.
Are they there in the compilation? So Pasha? Are they there in the compilation? Yes.
Not in the notebook. That's
my appeal paper book. PCL's appeal paper book at page. I'm asking for the guidelines.
I already
Guidelines starting at page 103.
103.
Start at page 102.
102 is the covering letter. Okay.
It's a covering letter, my lord. It might throw some light as to how this came up.
Thanks for setting up. Do we also have a copy of this order? 18 January 2019 NGT's order.
86 of 2019. I think we'll get it. That's not very difficult to.
Protection Act. Environment Protection Act.
You have the
Environment Protection
order.
No, that's in Mr. Rajada's order.
You have this order. Court is asking whether you have this order.
It's in 804.
Is it true?
Guidelines we have.
Yes.
But if you see what is stated in that covering office memorandum also.
Yes, Mr. Honorable
Says that
NGT.
the appropriate guidelines be issued by the CPCB in exercise of statutory power.
You have the Environment Protection Act. You have it.
It doesn't refer.
Environment Protection Act. Is very-
Page 90 of BPCL's similar.
90.
90.
You find a copy of the act?
Yeah, it's not.
No.
The NGT order of 2000.
The 2018 order.
90.
My lord, the order which your lordships were just now asking me is at page 90 of my appeal paper.
Yes.
Starting at page 90. That's an original application number 86 of 2019. Gyan Prakash alias Papu Singh versus Union of India.
No, but there also the NGT says frame guidelines and exercise of your statutory power.
Your lordships have the guidelines
So
at page
therefore-
103.
Yes.
Then therefore,
There's no reference made by them to which power they exercise.
Lord, that's what, Lord, I didn't find any power being referred.
Power to issue guidelines is there.
Under the Environment Protection Act?
Under the Protection Act.
3333.
Sorry, Miller?
33.
Of the Environment.
That is the central law. Yes.
Of the NGT. Lord, NGT Act.
Not NGT Act, the Environment Protection.
The Environment.
See, look at 33. Listen.
My lord is referring to the Environment
Protection Act.
The central government.
No, see, the central government, if it considers it necessary or expedient so to do for the purpose of this act by order, published in the official gazette, constitute an authority or authorities by such name or names as may be specified in the order for the purpose of exercising and performing such other powers and functions of the central government. So, the pollution control boards are constituted for this purpose. And if I remember correctly, there is a gazette notification also constituting such authority. That is how this environmental protection orders are issued.
Lordship,
you remember that?
I don't think it takes the guidelines.
It does.
Citing guidelines may not be taken.
Yeah, I came across that where the ex post facto consents were considered.
Which your Lordship said.
Yes. There, what is it called? Environment protection notifications or something. That comes in.
Lordship, may I draw my Lord's attention to a judgment of my Lord's Court, which is in convenience compilation at page 186, where this issue was considered.
The open convenience compilation. 186.
186, Indian Oil Corporation versus VBR, Menon and others. Lordship has that?
Yes.
Lordship, here, Lordship sees that the entire CPCB guidelines are extracted.
186?
186 of the convenience compilation.
This was a convenience for the holders. There's another convenience.
My Lord, have an older version than what I had. Para 46 at page 201, the entire CPC guidelines are extracted. Six, the CPCB guidelines are extracted.
Here there's a reference to section 5 of the environment.
That's right, Lordship.
Power to give directions.
Lordship, para 47 also is relevant, section 27 of the Air Prevention and Control of Pollution Act.
This is to power to give directions on the control boards constituted under the act or by directions of the
originally constituted under the water and then they continued that with the subsequent
so they
Not
issue
under the
notification.
environment protection.
not specifically, it was originally enacted under the water act.
But do they notify?
They notify, they give a notification saying that the concerned powers under so and so sections will be authorized by the body.
There is a notification to that.
Lordship will see para 43. They trace it first back to section 25 of the Water Prevention and Control of Pollution Act 1974. 43.
See, that is
what is consent to establish?
Mr. Giri, that is the basis on which that EIA notifications are issued.
Environmental impact
assessment. All those are issued by, I think, the central government or by the Pollution Control Board. But then the central government has issued notifications specifying the authority. That is the CPCB's authority to issue. So it will be the guidelines will be statutory in nature.
Guidelines per se.
Context of the consents to operate, they note the guidelines that page.
But the guidelines per se do not trace it to any statutory.
Yes, it does.
No, the guidelines do not.
Guidelines are
Look at
guidelines which a part.
It only says about statutory power. A large number of petrol in the country and directed that appropriate guidelines be issued by the Central Pollution Control Board in exercise of statutory power. So
That's
that
what
is
Milord the NGT says. That's part of the order.
this is your office memorandum.
Milord, that's the NGT's direction.
Okay.
That's the NGT's direction.
References to the
I'm saying that the guidelines as such
But the
do not
guidelines
state, do not trace it to any statutory power.
Lordship, if I may say something, Lordship, because if the guidelines emanate from the NGT, then the enforcement of the NGT, the argument is, doesn't lie before the NGT, which seems somewhat absurd, Lordship. Because the argument being made is that it doesn't. The guidelines don't emanate from the statutes, but they are pursuant to orders of the NGT.
Yes.
But surely then the NGT has the power to consider applications for violation of those guidelines.
No, then it goes to the power under 14 or 15. It goes to 15.
One way or the other, Lordship, because this judgment settles the issue.
It becomes cyclical because the NGT in that judgment said you exercise your statutory power and come out with guidelines.
That's correct.
And then the CPCB comes out with guidelines. Once those guidelines are brought up, then they come within the ambit of the scheme.
Statutory board.
Once they come within the ambit of the scheme, then again it goes back to the NGT if there's violation, because then you can look under.
My lord, violation is not the violation could be challenged. But violation will have to be, for the violation to be challenged under NGT, before the NGT, it has to be brought under section 15.
14 or 15.
14 or 15.
Yes.
14 it doesn't apply here.
Why?
Because, my lord, the challenge is not to the guidelines. Even when the original applications were filed, it is not as if, my lord, it is not within 6 months from the date on which, my lord, the permissions were granted.
No, you can't date back to the permissions. When did you start operating the outlet? That is when the cause of action would arise, is it not? If you have an approval, you keep it in your drawer. That is not within public knowledge. That is not when a cause of action would arise.
No, my lord,
it is not put in the public domain that so and so has been given approval under the fire NOC or.
The permissions were granted, and the permissions have been granted on a particular date was made available to the same applicant in the earlier round. It was made available to him, my lord, in 2020. And it is thereafter that, and when we got ourselves implemented, my lord, not in the first.
His success is on the basis that the CPCB guideline is not followed, is it not? So your approval under the fire NOC, the DM's approval, those are not relevant.
My lord, if those have to be, no. They are project specific, they are site specific. No. If they are not challenged.
They are not in the context of the CPCB guidelines. You need to pass this hurdle also.
Mr. Giri, now 2021, it was established. When did they file the first
original application?
In 2020.
In 2020 itself, before the approval was given.
Before the approval.
So we had, just to clarify.
Not against us.
We had come.
Not against us. Without making us a party.
That was the first.
No, my lord. I'm saying that there was no challenge to the establishment of the retail outlet, my lord, in this place.
Probably they only civil appeal which came before the score was his civil appeal.
That's correct.
Where he was complaining of inaction.
Yes, but not against us.
That's fine.
We got ourselves included, my lord, in the appeal here.
It was in the
Lordship may just, Lordship, to put this at rest, Lordship may just see the first document in this convenience compiler.
We'll go one
that will settle the issue.
We'll go in.
Very
well.
Let Mr. Raisada complete, and I'll make.
It was in the nature of PIL petition before the NGT. So my lord was directing me to look into the office member, the guideline. So your lordship may kindly see the guidelines. Well, these are the guidelines which are filed as Annexure A10 to Civil Appeal of BPCL.
Guidelines are at which pages? Sorry.
102. 10.
Of BPCLs. BPCL paper. Yeah.
So what
now? Which guideline are you in violation of?
Last page at page number 107.
107. Yes.
Well, here I will say one thing. That so far as NGT is concerned, NGT had directed the CB to take a call on the safe minimum distance. It had not provided any formula or whatever it is. It had not provided any specific that place or whatever. So therefore, they say that you frame your guidelines. This is what a simple direction was. This was an additional direction in addition to the what was before the NGT.
Which is it? Citing.
So BPCL paperbook page number 100, last paragraph says, in view of the expert committee having already gone into the matter, the finalization of timelines as contemplated in the report, because there was an expert report.
Where are you reading?
Page number 100 of this, the NGT order of 2019. On the same paper. The last paragraph, because expert report was being considered, in that expert report there was no citing criteria.
Section 15.
may also add that a safe distance from the residential areas must be maintained for any new outlet to be set up, which may also be specified within 1 month, keeping in view the health and safety of the inhabitants. Can you see that this is what they say residential area? There is an issue also, so far as the MDDA guidelines are concerned. So MDDA guidelines, if MDDA guidelines provide the petrol pump to be established within the residential area or in a mixed area or in a commercial area, there was no guideline. For the first time, these guidelines came that residential area designated as per the local law, there should be the safe distance criteria and come into it. So this aspect of the matter also went before the NGT, and how NGT has responded to this type of issues.
What is the specific violation? Is it on residential area or school or hospital? What is your specific violation? Now they complain of.
They say that it is in the residential area.
No school or hospital?
No, no,
okay.
Nothing.
Page 107 speaks of schools, hospitals.
So school and hospitals, we are not there.
And residential.
And residential.
Only residential area designated as per the local law.
You are within 30 meters, is it?
They say that it is 25 meters, therefore it is one from one house. So there is no, I'll come on merit if I am within the guidelines, but first I have to address my lords on this aspect.
First of all, is it designated as a residential area? Is that area designated as a residential?
No, it was in 2020, 2013, it was declared as a mixed area, mixed zone.
Mixed zone.
So
that's in the zoning regulation.
Zoning regulation, which were existing since 2013 and 2018, the proposal to approve the land for retail outlet was in 2000.
Now it is not designated as a residential area in the zoning regulation.
Yes, after that regulation, it is a mixed zone.
It's a mixed zone. Then it,
so far as the roadside is concerned,
the siting criteria would not apply to.
That's what the NGT view is. That was the High Court view is on this aspect, and High Court view is on one aspect also.
Then why does the NGT hold against you?
NGT did not discuss it all. NGT overruled its own two-bench judgment that the siting criteria will be applicable only on those establishments wherein the permissions are moved after the guidelines. This is what one
in the present judgment. How does the NGT deal with this particular siting criteria? How does it apply it to you?
NGT says that as we have held in stone crushers matters, that stone crushers are causing a lot of pollution. Therefore, all stone crushers existing should also go as per the new policy, the stone crusher policy, following that judgment.
That judgment is followed.
This is what. And against that judgment of civil appeal, in that case, the civil appeal, there is an interim order of this court to continue those stone crushers.
See,
what has been relied upon?
Prima facie looking at the guidelines. Prima facie looking at the guidelines. This distance as far as petrol bunks are concerned is not because of the pollution. It is to avoid hazardous accidents. More for avoiding hazardous accidents.
Hospital.
So school and hospital, that's not.
It doesn't go for any pollution.
I'm not there. It's only the issue is whether it is mixed zone.
So that
if it is mixed zone, NGT has taken a position.
So the stone crushers cannot apply here. Stone crusher.
NGT followed that judgment. That's what I'm saying. I'm simply saying that that judgment was followed. And my entire case
is also saying something in your favor.
Page 4, Lordship may have.
That's why Mr. Pasha has interfered.
Page 4, Lordship may have. That question.
Let's now complete.
The NGT view on this is on page 4, Lordship. The fact finding.
Let him complete thereafter.
Yes.
So far as that aspect is concerned.
Your case is that this siting criteria would not apply at all.
Will not come into picture in those first aspects, that in those matters wherein the ball has started rolling prior to that.
Where do you find the zoning regulations showing that?
Yes, madam. That is area. Zoning regulations.
Leave for 5 minutes.
The BPCL filed the zoning regulation amendment in 2013.
Which page?
I'm appearing for the MDDA Development Authority. We got to have the compilation of the English translation.
Asking what is the area?
Is this a residential area?
Or it is a residential.
You marked it as a designated it as a residential.
Which document? Which document?
Notification.
My lord, your lordship will find that in the master plan, your lordship will kindly have page 43 onward.
43.
These are the zoning regulations after the amendment of 2013.
43.
2013. And that notification you will find at page 13, Lord.
30.
30. With the English translation at page 32. And by this notification, Lord, the master plan was amended. And the amending zonal regulations started.
No, where is the notification which shows that the land in Khasra number 1516?
Notification is not there, Lord.
Then how do we know where the residential zone is?
But under these residential zoning regulations, Lord, the petrol pump is permitted. And if, Lord, the area that falls within the residential area.
How do you say by shows by notification?
Your lordship may kindly see for a moment the annexure A1 of 44 page BPCL listing and approval. It is there. Notification is fine.
Which page?
Annexure A4, A1, page 44.
This is
28th of November 2013. And lordship may come straight to page number 50. This is the amendment in the master plan.
Area regulations, page 50. Mixed residential area.
It means primarily residential area, mixed residential area, unplanned, unorganized residential area. Am I right, my lord?
Yeah.
And then the lordship may come at page number 51, clause 1.2.
No, but where is the actual designation of particular areas as per this classification?
So that is actually not in dispute, but that this is a residential.
We still need to see it. What is a mixed residential area? Does that mean that it's half commercial, half residential?
Yes, madam.
That will count as a residential area? 20 square meter area in residential building, group housing, guest house. Will be for professional use, doctors, clinics.
This is the permitted use.
Shops.
In order to
The plan would continue to apply. Your 2013 notification is in relation to calling for objections for a 2025 master plan. So what does your master plan of 2005 to 2025 say? Pages 1 to 29. What does it say?
It is for 20 years, Lord. Earlier, the original master plan, Lord. In the residential area, the petrol pump was.
It's about the
2013, there has been an amendment to the zoning regulation.
But you have to show us the specific notification in relation to this piece of land to indicate whether it was falling in a residential area or in a commercial area. What kind of area was it falling in? You can't just say residential areas and there's no dispute that this is a residential area. It's neither here nor there.
See, your master, the document you showed us in page 32, that contemplates a master plan of 2025. Objections were called for. So if the master plan came only in 2025, even if this area is here,
Your lordship may kindly see paragraph 3, they amended it.
25.
This one is what we
1 to 25.
2005 to 2025.
Where does this area classified as residential? What is that?
Your 1 to 29 page master plan, where does this land fall?
Is the translation starting from 15?
50.
So they amended by this amendment, they amended the master plan.
That is for master plan 2025. They've called for objections from 2013 onwards. So as to come up with a master plan in the year 2025.
This master plan was effective for 20 years.
From 2005 to 2025.
And they amended by clause 3.
It was amended in 2013.
Please look at your 2013 notification. Page 30.
At page 32.
Paragraph 3.
The first paragraph. In order to receive objections and suggestions regarding amendment of the master plan 2025 by the state government, the master plan amended by notification dated this 15 March 2012 amendment, we don't know what that is. But this 2013 is only in relation to the master plan of 2025. So you need to show us what this 15 March 2012 notification is. That seems to have amended it. This is not an amendment. This is calling for objections so as to formulate a master plan for 2025.
Look at the last paragraph.
Yes, my lord.
This notification related to amendment in Dehradun Master Plan 2025. So here you only contemplated an amendment in 2025 for which you call for objections. See, that is what.
Your Lordship is absolutely right. By reading
This notification was effected immediately, my lord.
master plan amendment in the master plan
25.
But
This says this
You
is.
can only go by the recital.
This says this was effected immediately with immediate effect.
How can that be?
Well, your lordship may kindly say because this was paragraph 3 and 4.
And this only referred to master plan, solar regular and the proposed commercial areas.
Look at the Hindi version.
Already they are identified by Khasra number, etc. So therefore, the government says that the master plan is amended from 2013. It has to be in accordance with, so that Mahanagar.
Wait. To effect with the areas shown as residential, commercial, mixed and all that. That you will have a master plan with the maps. Unless
You're
you
not
produce
showing
that,
us
you can't.
that. Where this particular piece of land falls, is it in a residential
That is
area?
that locality.
Land in a vast area, 15-16.
Just showing us what is permitted in a residential zone is not enough.
Actually, roadside portions were
Unless this plot falls in a residential, a designated residential zone, that siting criteria won't apply. Therefore, you first need to show us where this land falls actually.
When the designation was done.
Sorry?
When the designation was done.
That's all. That's
This
also
2000, perhaps this 2005 to 2025
Designation is
master
on ground.
plan.
Designation is on
the ground. Yes.
On the ground, because they would have notified it, because I have dealt with it as an advocate in Hyderabad. I have seen these plans, because there was a public interest litigation which was initiated on the similar issue, on violation of zoning, and I was the amicus there. So I had to hound the municipal authorities to get me the plans to show which land was falling where.
They are always elected.
They're very, very reluctant. Even as an amicus, I had difficulty.
Well, MPDA proceedings will show one thing, that these retail outlets were established on the roadside.
You will be in the best position to show us where this land was classified.
It would be somewhat like this. I
correct.
So this is a copy of that, but this is of Haridwar. So they have a similar thing.
So you would have different numbers and you will show different areas, huge plans will be there. You'll need to open them up, they'll cover half this table.
And that has been notified also.
This exercise should have been undertaken by the NG team.
No, not necessarily. That should have, looking into
The challenge is.
According to
Please have a look at the.
they only
Why do you want
applied
to
this
go
one.
back?
2 days time was given. 2 days time was given to
Why
this
do you
one.
want to go back? We'll look at it.
Sorry.
Why do you want to go back?
again?
No. We are saying that therefore, the NGT did not undertake this
No,
exercise.
they seem to have just applied some other judgment to you.
That's
Just
not
don't rush
applied.
us.
Don't rush us, there is pollution.
Are you, Mr. Pasha, in a position to show that this land is classified as a residential zone area?
Lordship may, I'll show Lordship 2 documents. One
Answer this question, without first being convinced
Lordship,
that this land falls in a residential zone. Because there's no question of it being within 30 meters of a school or hospital.
Lordship, please.
That doesn't arise. So the third one which could apply is if it is within 30 meters of a residential area.
Designate
A residential area would mean residential zone within the zoning regulations.
Lordship, please.
So unless we are shown that as per the zoning regulations, this piece of land falls in a residential zone, that citing criteria cannot apply to it.
Lordship, please. Lordship, on 2 occasions, fact-finding committees were
Fact-finding won't do.
Where
Going and seeing and saying that yes, there are houses, they won't do.
See, that is
Houses are built in all over the place without reference to the zoning regulations. We need to see whether it is a designated residential area. That perhaps he is the best person to answer.
See, residential area as you perceive it, or as the observer perceives it, is not the issue. If somebody goes and finds a lot of
Because
residential
in residential areas, we have shops running all over the place. That doesn't make it a commercial area. It still remains a residential area.
That is a statutory exercise of.
Therefore,
that's what.
residential zoning, is this part of it or not?
And it should be demarcated in a map and notified in the gazette.
That's correct. Notified.
Unless that is notified.
Objections are invited and ultimately, my lord, it is finalized.
Well, show it to us, then we'll adjourn it to next week. Next week, you'll be able to get them.
Yes,
As a standing council, you should be in a better position to do it than I could as an amicus.
Same difficulty with the standing council also.
They are very, very difficult to.
Manoj delineates the residential, commercial, the
industrial, it was for the petitioner to have
entertainment, everything is segregated.
After 2 weeks. And stay after.
may I just show Lordship in the same SLP that Lordship has, the NOC which was granted by the DM has certain observations in this respect.
Refer to the zoning also?
Lordship will just see.
Which page is it?
Lordship, it is at page 123 of 8042. Mr. Giri's SLP.
23.
123, and I am drawing my Lord's attention to 129.
Yes.
This is the description of the land. They give the boundaries.
Residential units are.
Admitting so and so is situated beyond 25 more meters. There are no trees. West residential building and land belonging to so and so. North so and so. Then Lordship, the paragraph below that starting Shri so and so.
That's my reference.
Submitted a complaint.
5 lines down. Letter was addressed to Sub-District Officer Sadr Dehradun for conducting investigation on the above request, where the investigation report was received by Sub-District Officer from Tehsildar Dehradun, that according to the report of Tehsildar Dehradun dated so and so, residential population and buildings are located as well as local outlets are existing within the 30-meter circumference, and therefore it is not appropriate to grant permission for setting up petrol pumps.
He speaks of both residential as well as commercial. So we do not know what, according to the zoning regulations, this is.
That is again
zoning regulations are followed normally in breach. That doesn't mean that we just brush aside those zoning regulations. If an area is designated as a residential area, it continues to be a residential area even if shops open.
Just one more document of the MDDA itself at page 112 of this same paper book.
We are not concerned here with
Lordship,
The
here it's
existence of a residential.
Lordship, please, here it's better worded, Lordship.
112.
112 is this letter of the MDDA dated 10th August 2020.
Yes.
The second paragraph, in this regard, it is to inform that Khasra number 1560 is situated in village so and so, on comparing the distance shown in key plan, with the distance in Dehradun Mahayojana 2015 amended. 25-meter wide Mahayojana road is existing in the south of the spot in question. Remaining land beyond the extended road is shown as residential.
Get that? Shown as
24
residential
meter.
and notifying it as residential is different.
Transfer numbers on comparing distance, 24 meters wide Mahayojana road is existing. Remaining land beyond the extended road. So we don't know what the distance is here.
The 24 meters is the road, Lordship. So basically 30, within 30 because up here
Shown
the
as
description of the road.
Is that shown in the context of the zoning regulation or
Beyond 24, so there's a road separating.
Master plan?
Actually, part of 1560 being on the road, the roadside area was
Just produce the plan, please. The master plan of this Khasra number 1560, that particular plan you show us. Don't get us voluminous material there. One plan in relation to this Khasra number. This Khasra number alone. And Council for the, what is that? MMDA.
Masuri Dehradun Development Authority.
MTDA.
Masuri Dehradun Development Authority. And Council for the answer, it's time to produce the zoning master plan in relation to the land in Khasra number 1560, and more particularly the nature and usage of the settlement.
But item 101.2 and 0.3, the similar case may arise. That is arising out of a petrol pump in Haridwar. Lordship consider directing CPCP or the authorities to produce the map in that as well.
Seems Haridwar is perhaps available already. You have a plan or something?
We have filed it with one copy, which is, no, we haven't filed it.
What they filed will not be that.
We filed it, but we need to file an elongated copy because we know, but for your Lordship's convenience.
But you have a bigger
Yes,
plan?
yes, we'll get a bigger plan. Your Lordship may leave it on us, we'll get it.
Similar master plan should also be filed in relation to the land in 101.2.
0.2 and 0.3.
You're also appearing in this?
My lord, yes. According to us, it's unambiguous, but we'll place the plan.
Can we have it on next Thursday?
He wants 2 weeks.
2 weeks, very good.
18th Feb.
2 weeks, 2 weeks. Well, there's 101, will it be shown as 101 only?
Matter will retain its position. Because it's a partner, it will come on.
Yeah, one of my friend wants to request for his appearance to be put on call because some of they are not taken. Great,
Right.
most grateful. Most grateful. Grateful, Lord.
Please also.
My lords.
Yeah.
Before my lords start, my lords, I am appearing in 101.2, my lords. I have moved an discharge application. It's showing in the office report also, my lords. We tried to contact the clients from last 2-3 years. So my lords may discharge me from the.
You are referring for whom?
For Govardhan Singh Devang, 101.2. 102.1. 102.1.
2.1. This is not this. The list also has gone off. I don't know where it is. Which list? My process. This is.
Yes, I'll give you my. Oh, you write down the cost.
This. That's it.
102.1.
Oh, 102.3.
102, my lords, I have already filed my written submission also. But 102.1, there is a discharge application pending for a very long time. But I am ready with my arguments.
This practice here of discharging counsel, it's beyond my comprehension. Once you enter appearance, you file a wakalat. You can't just say I'm turning my back on my client.
My lords, from last 3 years, we have been trying.
Have you sent any registered notice with acknowledgement?
Yes, my lords, we
You
have
did.
been written.
Then you report no instructions. We won't discharge you. We'll dismiss it on the ground that
Please, my lord, please, my lord.
Because there's no point in discharging you and then making the registry run around trying to serve that person.
My lord, but we tried.
What do we do?
I,
Learn counsel for the appellant, Govardhan Singh Devanya, states that despite her best efforts, including issuance of a notice by registered post with acknowledgement due, she could not contact the appellant. A discharge application has been filed by the Learned Counsel on these grounds. We are of the opinion that in the event the appellant fails to show interest in pursuing his matter, he would not be entitled to seek further indulgence. The appeal is accordingly dismissed for non-prosecution. Yes, 102.
102, my lord, please. I appeal for the appellant.
Exemption from surrendering grant.
Yes, I was granted when the
Felling of trees.
There is a short written submission, my lords will find. In fact,
Trees on your own land.
Yes, my lords.
These trees were felled on
trees
your
on
own
my
land.
own land. In fact, my lords,
You need to take permission for it.
yes, if I will, my lords, if I will take my lords only through the written submission without even opening the file, whenever my lord will require, I'll show the pages also.
Yeah.
But we can just go by the written submissions, my lords, because certain dates are also very relevant. Dates and the status of the parties.
The Tehsildar and the collector are let off.
Yes. Now there are two lands.
You are.
I am Hastimal.
You are the owner.
I am the owner. I am the purchaser.
You are the purchaser of the land.
Yes. The vendors are not vendors of both the lands. They were never made the accused.
No, but who cut the tree?
No, the allegation is not just cutting the tree. The allegation is a little bit different. The allegation is that I'll just take my lords to the list of dates. But my lord may just see.
The other man is the Patwari. 102.1.
Govardhan is Patwari. Patwari. He is the Patwari. My lord may just have my written submissions. My lord may just have para 2 for a moment so that I just make the status of the parties clear.
Yeah.
And just before that, my lords may just take into account that there are two lands which are in question. Both were purchased by me. One is the land in village Balu, which I call as L1. And the other is a land, Khatra number 265/2, which I call as L2. Now, as far as L1 is concerned, my lords, I have been acquitted, even I have been acquitted.
These are in two different villages.
Yes, but the
Partly each other.
Yes, my lords.
These are in two different villages.
Yes,
are they adjacent to each other?
Villages are adjacent to each other. They are
These
both.
lands are also
yes,
adjacent.
they are both in the same district.
Right.
The Tehsil is also same. Tehsil is Dantewada.
But two different villages.
Yes. There are two lands. The context is that, my lords, as far as the first land is concerned, the Khatra number 1183, even I have been acquitted by the High Court. High Court has set aside the conviction of all the accused with regard to the first land. With regard to the second land, two accused have been acquitted and two have been convicted. I am one of the accused and the other accused is my lord 102. Now, my lord may just have para 5, the list of dates. Now, I purchased these lands, my lord, both the lands, in January 1991 and February 1991. The first land was purchased by the owner, the vendor.
What is this? It's the written submission. What is the written synopsis? Written synopsis. Okay.
Okay. Yes.
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 Yes, please. Now, the date of purchase by me.
11 January.
Yes, 11 January and 4th of February 1992. I purchased from different vendors the respective landowners. Now, as far as the sale deeds are concerned, those sale deeds are annexed in the additional documents. Both the sale deeds, I am represented that these vendors, they were absolute owner of the suit property. There is absolutely no encumbrance on the suit property. When I purchased the land, there are trees standing on the land. So they also give the consent letter to me that you can cut down the trees. We have received so and so consideration. Now, when I also purchased the land, at that point of time, all the revenue records were mutated in their favor, in favor of the vendors. Both the vendors, they were shown as the Bhumi Swami of the land. There is no dispute. There is not a single document produced by the prosecution showing that even revenue records actually showed that the land was a patta land.
Right.
Now, after I purchased, I wanted to cut down the trees. I had taken the loan for purchase of the land. So to repay the loan, I wanted to cut down the trees, for which there is a permission under the Land Revenue Code. Section 241 of the Land Revenue Code says that if you want to cut down the trees, you have to take permission from the collector. So the process is that I file an application, Patwari goes, he inspects the properties, he submits a report to the Tehsildar, and NOC is to be taken from the forest department because a lot of area in the Dandapara district is a forest area, and then the collector ultimately grants the permission. So I follow the entire procedure. There is NOC from the forest department. Admittedly, it is not even a forest land. Admittedly, these two persons were not tribals. Earlier, their contention was that they are tribals, but ultimately it came in the evidence that they don't belong to even tribal category. So I take the permission, my lords, on 4th of June 1994. That is there at annexure A10 of the additional documents. And then I cut down the trees. I sell it only to the forest department. I don't sell it to any private party. So government only purchases those trees from me. And I receive a consideration of rupees 4.66 lakhs from the government. Now, my lords, in the year 1998, in that Godavaraman case, my lords were actually considering, the issue was entirely different. My lords were actually considering the sale of land of the tribals to non-tribals by fraudulent means, or cutting down of the trees in forest areas. Private land and all these lands, my lords, were in fact not even the subject matter of those proceedings. But in that proceedings, there is an order passed by the Honorable Supreme Court, where it is said that CBI should investigate where the forest lands, the trees are being cut down, or the lands of the tribal are being sold to the non-tribals. So during investigation, the CBI registers an FIR. I am not an accused in the FIR. So they register an FIR for the period between 1992 to 1996, saying that in collusion with the certain officers, the landowners are actually getting the trees cut down, and there is a violation of provision of some aboriginal law there in the state. Ultimately, there is a charge sheet filed. So when the charge sheet is filed, all those persons who were made the accused in the FIR, they are not arraigned. They investigate and then they make me as the accused person, along with 3 officers. Now the allegation is that we could not have actually purchased these lands because sometime in the year 1984, these lands were actually settled in the name of these vendors. So these vendors could not have actually absolutely alienated or sold the land to the purchaser or to any other private person. Now please also take it, my lords, from me that there is no single document, no single exhibit produced by the prosecution in the entire trial showing that there is actually an order. That order of grant or settlement is not produced. So there is a provision under the Land Revenue Code, section 165(7)(b). It says if the land has been granted by the government to a particular person, basically the patta lands, in a layman's language. So if it is a grant, then you actually can't sell it to any private person without taking permission from the collector. But in the entire prosecution case, in the entire trial proceedings, in respect of both the lands, there is no actual order of grant produced. So if there is no actual order of the grant produced, I cannot.
What is this permission of additional collector you refer to in page 2?
Yes.
For cutting the trees.
Those are, my lords, for cutting the trees.
Cutting the trees.
So there are 2 kinds of permission.
Okay.
One is cutting of the trees, that I have taken the permission. There is no dispute. But then initially they tried to make out a case that I have illegally cut down those trees. Subsequently in the charge sheet, the case became completely different. They say that I have purchased the land illegally from the vendors. Completely different case. So they say that there is a violation of section 165(7)(b), which says that if the land is by government grant. But on record, my lords, there is no exhibit producing that government grant with respect to both the lands. Ideally, it is in the form of a lease document or a patta document. So they rely on certain registers, past registers, where that land is recorded somewhere as a patta land, settled in the name of, they use the word settlement, that these lands are settled in the name of vendors. Therefore, they assume that it is a patta land. Now, I'll show from the trial court records also, these lands were actually recorded in the name of these vendors from the year 1960s and 1970s. Now, my lord may just have para 6 now. There are 14 witnesses, but only 4 prosecution witnesses are relevant. Most of them, my lord, they concerned with the sanctions and the various procedural aspects as to who signed the Patwari report and then who signed the Tehsildar. But as far as I am concerned, my lord, these 4 witnesses are relevant. Paragraph 6b, my lords, PW1, he is the deputy collector. He says that according to me, they should have taken permission because the land was settled. But when he is asked in the cross-examination, he says that the CBI has not shown me any document of patta or grant. Then there is PW4, Ramcharan Goti, who was deputy collector. And he says that in the file there is no actual document of patta, no actual grant. Then PW 13, my lord, is one of the inspectors of the CBI. He says that it is correct that at the time of recording of statement of Chandan Singh and Dhananjay Singh, they told me that they are covered in non-Adivasi backward class. It is correct that they had told that their land is ancestral land. Then again, my lords,
what does that mean?
Yes, my lords.
What does that mean?
That they are not Adivasis. So that only this
That they
tribal
are-
lands cannot be.
That they are covered in non-Adivasi backward.
Yes, I'll show from the my lord's trial court judgment also.
They had
But for the purposes, my lords, only of the evidence, please also note the evidence of PW 14.
Yes.
Lords, where the IU is also not able to show the exact document from the records. Where is that actual patent? He also says that even though they have actually sold it, I have not made them accused. And then I produced, my lords, my witnesses, basically the relatives of the vendors. They say that these lands are my ancestors, were our ancestral.
Then,
yes. Then my lords may just have para 7. I have summarized the relevant portion of the trial court judgment. Till page 77, my lords, the issue is with regard to the validity of the sanction and all those things. I am not concerned with the sanction. Now, what the trial court does, my lords, the trial court actually starts deciding the case like a revenue case. It says that I will decide the nature of the land. What is the nature of the land? Whether it is of the ownership of these vendors or these were government lands.
So it decides that this is not Malik Makbuja.
Yes, so Malik Makbuja basically is of absolute ownership. Even Marhan land, my lords, there is no law which says that Marhan land is actually a government land. Marhan land is like a village land. So, but there is absolutely no provision anywhere in the entire Gujarat of the Madhya Pradesh Land Revenue Code saying that Marhan land is a government land or anything. But my lord may just have page 89 and 90 for a moment of the SLP paper book.
Yes. 89?
Page 89. Only the relevant part, my lord, I am showing because otherwise the trial court has basically tried to interpret what the land revenue code means and the other circulars and all those things. Paragraph 43 onwards. If I may just read, my lords. In exhibit PA1, in bracket E, no, exhibit PA1 is actually, these are the mutation records. The land of Khasra number 265 in dispute of this case has been referred as the land of Amma Marhan and its area has been mentioned so and so. In this document, it has been mentioned that the land is the land of Marhan category. Therefore, on perusal of this document, it reveals that earlier in the year 1964-65, the land located in village Chitalur so and so, some Amma Marhan was marked with land of Khasra number 265. In accordance to entry prior to year 1955, the land of this Khasra number exhibit so and so was considered as the land of Chandan. I'm only trying to show that as a purchaser, my lords, all I could have actually seen were the documents which were available in the public domain. The revenue records, the sale deed was considered as the land of Chandan. This Chandan is my vendor. So even in the year 1945, he was recorded as the owner. But entry of this document made at serial number 6 and 7 has been crossed with reading, but any reason for doing this has not been mentioned in the record. However, it is proved with this record that Amma Marhan land situated in village Chitalur later on had become the land of Khasra number 265. But on marking name of Chandan with reading record of exhibit A1E, it cannot be considered that in the year 1965-60 or prior to it, this land was ancestral land of Chandan. 45 says the document exhibit A1F is Kishtbandi Khatoni of 1986-1987, land of ownership of Chandan, son of Sadeh, which is situated in village Chitalur. Document by way of registered sale deed, Chandan has been referred as the owner land. Yes, till page 92, the trial court says that the revenue records actually showed Chandan as the owner or Abhumi Swami basically in the revenue records.
Now, you are convicted under 468, I guess.
Yes, so I have been convicted, my lords. I have not been convicted under PC Act by any means, even a conspiracy. I have been convicted under section 120B, read with section 420, 468 and 461. Now, as far as forgery is concerned, they don't, my lords, explain as to what is the forgery. It is not a case as if I have signed any document or the person who has actually signed those reports has not signed. For forgery, it is necessary, my lords. For, even in writing section 468 prima facie, you have to actually make.
Mr. Rajkumar, anything? What is there in this?
No, first of all, those two vendors, they have not argued to it if it is a case of conspiracy. No.
There's
That is
nothing
all.
legal against him. What do you have?
No, it appears for us as we go as the buyer beware, if your lordship is.
But you don't even have a document to show that this is a assigned land.
I'll point out from the evidence of the witness.
Lord, he's read out what they said in cross-examination. He says that the CBI did not show me any document, one witness. The other one says, I have no idea whether this is assigned land.
And you go by a red cut mark. No authentication, nothing. The records clearly show that somebody cut it off. From 1955, it is with Chandan.
So far as that permission for cutting the tree has got permission, no. That is not.
No, you don't produce anything to show that he should take permission for purchase also.
And what?
Only one fact, my lords, till date. Ideally, my lords, as far as my understanding is concerned, whenever you actually purchase a property in violation of the provisions of Land Revenue Code, the government will immediately resume the property, saying that you will take it back. Till date, my lords, they have no action was ever initiated.
Only this punishment.
Yes, this because
Case number is the only evidence, my lord, so far as
some register.
Yes.
That's all. No document.
That is.
And that to what? 1945 Chandan Singh is there.
55.
45. 55 or
55.
55.
And Chandan, that name has been
settled to by the government.
No authentication.
Because they were the.
And even according to that code, it's not as if it's completely barred.
There is a time period.
You have to take permission from the collector. So it's a curable defect, if at best.
And not only that, unless it is a notified area of tribals, you need to get a permission only within 10 years or something.
For that, there is a separate provision in 160.
This is not even tribal.
It's not tribal.
Private land.
So the sale deed also, if your lordship will please to see this.
They claim to be owners. If we are the boom.
Nothing is mentioned now.
They need not prove it. You registered the prosecution. You have to establish it. You can't ask them to prove that Chandan had it from 1960.
It is a case of the prosecution that it's a conspiracy, my lord, by virtue of which the settled land was purchased, my lord. And then thereafter, my lord, the patwari that is going.
See, for that you have to primarily establish that it is a settled land, for which there is no document.
No, settled land is only, my lord, that case, land allotment case. That's the.
Nothing, no document produced.
That is the. We have produced the settlement register exhibit P5.
The appeal number 3398 of 2020. By judgment dated 3/7/2013, passed in special criminal case in bracket CBI number 51 of 2004, comma, the learned special judge within bracket CBI, comma, Raipur, Chhattisgarh, convicted the appellant under sections 420, 468 and 471 of the Indian Penal Code, read with section 120, capital B of the Indian Penal Code. 120 thereof. He was sentenced to a maximum of 3 years of rigorous imprisonment in connection with his conviction understated with fines in relation to each of the offences, coupled with default sentences also?
Yes.
Default sentence. How long were you in prison?
No, I was always on bail.
Always on bail. The conviction and sentencing of the appellant stood confirmed by the High Court in criminal appeal number 679 of 2013, when a division bench of the Chhattisgarh High Court dismissed the same with a judgment dated 29/7/2019. The allegation against the appellant was with regard to his purchase of 2 extents of land under sale deeds dated, registered sale deeds dated 11/1/1991 and 4/2/1991 from one Tirpal and one Chandan Singh. These lands were situated in which villages?
In village Balud and Chittalur.
Village at the top you mentioned, Balud, BALUD, and village CHITALUR, both situated in both Tehsil Dantewada, District Bastar, Madhya Pradesh, at that point
Now
of time, within brackets, at that point of time. According to the prosecution, these lands were not alienable by the vendors on the ground that, which provision of the Land Revenue Code you said?
Section 165.
You extracted it.
Yes, ma'am. Page 3, I have extracted.
Were not alienable by the vendors in the light of Section 165 within brackets 7-b of the Land Revenue Code, Madhya Pradesh Land Revenue Code, 1959. However, we find that there was no absolute bar posited by the said provision, and it merely required that requisite permission, required that permission be taken from the collector prior to permission be taken from a revenue officer not below the rank of a collector for prior to such alienation. On facts, we find that the aforestated provision did not even stand attractive in the case on hand, as no clinching evidence was produced by the prosecution in proof of the subject lands having been allotted
by
or granted by the state government or the collector subject to conditions. The witnesses produced by the prosecution also failed to substantiate this aspect of the matter. In the absence of this foundational fact, the trial court was in error in convicting the appellant on mere surmises and conjectures. The High Court also fell into error in confirming the said judgment of conviction and sentence. The appeal is accordingly allowed. Mention one fact I forgot to mention. Exemption from surrendering was granted by this court on 30th September 2019. 30th September 2019. The appeal is accordingly allowed, setting aside both judgments.
Lodge.
103.
Oh, should not be. Yes, Mr. Lokesh.
Yes, on behalf of the municipal corporation.
5 minutes, you can lay the foundation and continue
Yes,
tomorrow.
briefly, the dispute in this case is whether this land vested in the Gram Panchayat or in the.
Just turn this around so that you can speak in.
Sorry.
Is that on? One is showing up red, the other is not. Both are on?
These are on, but I do. It doesn't take the weight of two lawyers.
It seems to be on. Yes.
Lord, I'll try to be as loud as possible.
Yes.
Lord, the dispute is basically I would represent the Gram Panchayat, which has now been taken over by the Municipal Corporation, Gurgaon. This land is in District Gurgaon. The dispute.
But the appellants are individuals, is it not?
Yes, Lord.
One appeal is by the individual who is resident of the village.
4 appeals.
There are 4 in this. The rest are all municipal corporation. But where is the council in the first matter then?
I'm there.
You're there. You're conceding your advantage to the municipal corporation? Yeah? All right. Well, he's conceding.
Yes, he is resident of the village. He interests are same. Lord.
Oh, I see. You are all
Yes.
sailing together.
Yes, yes.
Oh, I thought he would be.
No, his interest is same. Lord.
Very
He's- yes.
But there'll be some documents which we'll refer to from his petition.
Oh,
Which may allow.
no, as long as you're sailing together, then there's no difficulty.
Yes.
I thought he would be opposed to you. You are opposing.
Yes, my lord. The preliminary issue will be the locus, my lords. About the individual, because these proceedings arise out of a statutory declaration that we sought, that the revenue entries of 54 were contrary to the previous records. And except the revenue record, the claim of the Gram Panchayat, which is subsequently represented by the Gurgaon municipality, has no legs to stand. The individual in his individual capacity is not in a position to maintain these proceedings. The Gram Panchayat.
I think it's my turn, I think.
Yeah, no, I'm just giving an overview. my lords. Much
Before you chop my legs and arms and everything.
He is indicating to you what hurdles you will have to.
I thought he would keep his gunpowder dry. But
No, this is the only point. Lordships have read the files earlier.
We have not read the file. Final hearings, I don't read.
Oh, I'm sorry. Last time we had indicated that.
You never know when you take an adjournment. What is the point of going through something like this and then you'll come up with an excuse and say, I don't feel like arguing today, I'm going to Lodi Garden.
This is the
So what do you do with that?
typical Haryana, Punjab litigation, where a lordship will have to go through a large number of those jamabandis, then revenue records, wajibulars, etc., etc.
Land in Gurgaon, obviously.
Yes, Lord, land is in Gurgaon.
It's a
Common Lands Act in
Yes.
Gurgaon.
It's
That's
something
right.
again.
Lordship is
should have
the
read this in
respondent
Hyderabad and Andhra.
is a builder.
Maybe he's
No, I'm not. Listen, he was trying to chop my legs. I'm trying to do the same thing.
Respondent is not the builder is behind the respondent.
He's there, my lord.
Take it somewhere in the background. Gurgaon, obviously there will be a builder lurking in the background.
Builder is not a activity, my lord, which is prohibited.
No, nobody is saying it's prohibited.
So you don't paint them like this.
I'm only using the same paint he used. That's all.
I was on locus. Builders have locus. There's a difference.
Absolute locus, Lord. Builders build the country.
Okay, so we'll let you off today, so you can start tomorrow.
Yes.
List tomorrow is the first item in the regular hearing matters.
104 million. In that application for premature is pending million, the state million.
Actually, it will take 3 months to.
What do you want?
Matter may be listed after.
You want an adjournment?
Yes, Lordship.
Already
Premature release is pending, Your Lordship.
26th is also over.
Already he is on bail.
26th January is also over. You're going to wait till August now.
Lordship. No, Lordship, actually.
This generosity only flows at Republic Day or Independence Day, is it not?
No, Lordship, it is
Then-
for the company that Your Lordship. Anyway, he's on bail.
But you let Republic Day also pass. How many people did you release on Republic Day?
I don't have the restriction.
Why was he not considered for that? How much time do you want?
3 months.
3 months.
I mean bail million, I am not.
Oh, I see you. You're out of bail. The Council for the State of Tamil Nadu states that the process of considering don't say process of, the consideration of the petitioner's case, appellant's case, for grant of premature release is still ongoing and seeks time on that ground. Based on 3 months you want. You take it up after the list on 22nd July.
Great.
Publish.